Good afternoon, all. This application hearing is in the matter of CFI 082-2024 before His Excellency Justice Sir Jeremy Cooke, with a sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Hadif and Partners. Lead counsel is Mr. Jamie Riley, KC. The second defendant is represented by Al Adarus Advocates and Legal Consultants. Lead counsel is Mr. Riaz Hussain, KC. Thank you, Honor.
Thank you very much. Yes, Mr. Hussain.
Your Honor, you should have an electronic bundle with 2,432 pages. Have you had a chance to consider the skeleton arguments?
Yes, I've read the skeletons. I've read everything on both parties' reading lists, and the bundle I have has 2,435 pages when I downloaded it. So it may be that
I might be behind you.
Well, your page
pages are
maybe 1 or 2 pages out in consequence, but I'm sure we can manage.
Yes. So, Your Honor, as you're aware, that this hearing is to consider 2 applications by the second defendant, Lane, an application for the stop order made without notice on the 25th of October 2024 to be discharged, and an application for immediate dismissal and or strikeout of the substantive claims made against Lane. Summarily, as you'll have seen from my skeleton, both the stop notice and the claims are based on a factual assertion that Lane received shareholding in the first defendant, EFS, from 2 companies now dissolved, Walnut and Ban Canada. And Cayan, the claimant, asserts that the shareholding that Walnut and Ban Canada held in EFS, or at least 3% of that, is its property, essentially. The basis for the application before you today is that there is no real prospect of Cayan establishing that such a transfer took place of the shareholding in EFS from Walnut and Ban Canada to Lane. The sole evidence that Cayan has provided for this assertion, which is a gravamen of its case, is a verbal hearsay statement allegedly made in or around early 2021, and the maker of that statement, Mr. Gubar, has denied making it. But even if the court found that the alleged verbal hearsay statement in itself comprised sufficient grounds to allow this claim to proceed, such an alleged statement is contradicted by the documentary records, which show that in between April 2019, when it is common ground that Walnut and Ban Canada's shareholding in EFS was extant, it was undisturbed, and the 10th of September 2019, when it is common ground that Walnut and Ban Canada ceased to have a shareholding in EFS. In this period, the documentary records firstly show quite clearly in my submission that Lane's shareholding actually did not increase, and in fact Lane is able to account for the shareholding that it had in this period, and there is no real prospect of establishing that the shares came from Walnut and Ban Canada.
Sorry. What do you say about the lacuna that you haven't produced the share registry for the whole of that period?
Well, Your Honor, that assumes that there are further share registry documents. We produce a share registry that we have. We have shown that at the period when the Walnut and Ban Canada shares were extant, we were at 21%. And we have shown that we did not go above the 21%. And there is no basis for suggesting that other documents exist that would show otherwise. And in fact, when we look at sorry, I'll keep interrupting you, Your Honor.
Sorry, it's the usual problem when we have when we're on Teams. But have you produced the complete share registry for the whole of the relevant period?
Your Honor, mine's understanding is that there is no share registry as such produced on a periodic basis. The share registry is issued by EFS at a time of its choosing, and we have produced the share registers that we have and that we are aware of for the period between April and September 2019. We do not understand there to be any other document produced showing the shareholding.
I'm sorry, is there not a register with consecutive pages?
not that I'm aware of. What we have been given has been a printout generated on these particular dates, which we understand coincides with the timing that it was generated by EFS. We don't have access to any other records, but what we can see.
I understand the dates of the 14th of May 2019, the 24th of September 2019, and the registers as they appear on those dates. But what appears to be being said by Mr. Riley is, well, what about everything in between? You might easily have, Lane might easily have received the shares and transferred them elsewhere during that period.
Yes, but there's two things. One is, what is the premise for saying that Lane may have received the shares, or any other Mickey Mouse company may have received the shares? The only basis for that is a alleged verbal hearsay statement. And what we have been able to show is, how the shareholding actually fell from the 21% to the 17.74% in September 2019. What's also worth noting, I can take you to quickly, Your Honour, because it's not something I had identified in my skeleton, but I will show you, is if we go to the September shareholding, which is at 763. Actually, if we start, let me just start with the April one, which is a 749. I beg your pardon. So if you start at 749, you'll have to rotate the view. So I apologize for that.
Yeah.
Oops. Just bear with me, just behind you on the rotation. If we go to 749, what we see, if we go to the second page, 750, we see EFS Facilities Limited has a 19.5% shareholding. Do you see that? 750, top of the page.
So bear with me a moment. Yeah, it's 751 in my copy, but there we go.
I'm so sorry, Your Honour. So you see that 19.5%. I'm sorry, Your Honour, I might be slightly off on some of these pages now. And then this is bear in mind, this is the April register, and then we see on the same page the 21% for Lane, which was then Vision Investments and Holdings. You see that?
Yes.
And then we go to the next page, and we see what is common ground, the Walnut and Ban Canada holding. So this is in April. We then go to.
Well, I've read all this, Mr.
Yes, there's just one point of emphasis that I hadn't made. If we go to the September shareholding, share register, which is on in my bundles at 763, you might have it a page after.
Yeah.
What we see if we go down to the next page is that 19.5% shareholding, which we saw for EFS, is gone. As are obviously as is obviously the shareholding for Walnut and Ban Canada. But if we go to the last page of this document, 765, you see a new company appearing called Al Adan Real Estate Company. This is a Kuwait company. You see that, Your Honour?
Yeah.
That has acquired on the 10th of September 2019 a 43.11% shareholding, which is slightly higher than, because you see some of the figures go down slightly. If you combine the Walnut and Ban Canada and the EFS shareholdings that have disappeared, they come to just below that. And the 10th September 2019 date coincides with what Cayan says is the date that Walnut and Ban Canada ceased to be shareholders. So we see that if we go to page 121 of the bundle, in my case, it's a report on EFS Facilities Management. 121. Do you have that?
I have to type it in, so just bear with me.
Of course.
So what am I looking at?
It's a document headed EFS Facilities Management. It's basically a company report. You might have it at page 122.
Yeah, 122. Yeah.
And then if you go to the second page of that document, you see a headline, former properties, and you see shareholders. And if you see the last two entries, it says Walnut and Ban Canada until the 10th of September 2019. So that 10th of September 2019, and this is obviously pleaded by Cayan as a date that the shareholding ceased. That date, if we go back to the September.
Yeah, well, I've just seen that. Yeah.
Yeah, that date coincides. I mean, obviously, I don't have instructions on what happened to those shares, but that's where we are. And just, you know, you have my point, Your Honor. I'm going to expand on this, but you have my point that the positive evidence, the only positive evidence of the shareholding going to my client is this alleged hearsay statement in 21. And I'll talk about that more in a moment.
Yes.
But when my learned friend says for his client that, well, we don't have a snapshot of what happened in between, that firstly assumes there's something to trigger that snapshot, but also assumes that there is a likelihood of there existing a particular document that would show the transfer, that this is going beyond what the authorities call as waiting for something to show up. But obviously I'll expand on that, but that is really the essence of the case I'm going to put to you, Your Honor.
Yes.
So,
and what do you say about the conspiracy allegation, which is simply,
yeah, sorry, go on.
That the object was to deprive the claimant of its shares?
Right. So just looking at that, that's why I think I've been careful in the annex to my skeleton to go through.
Yeah.
Each of the I'm trying not to be pejorative, but each of the items said to point to a conspiracy, none of those allege any unlawful act by the director, let alone an unlawful act by a former director that can be attributed to Lane as a company. And what in my submission they seek to be doing is just creating an impression. And we also have to bear in mind an important thing. The claim is in unlawful means conspiracy. Obviously, there is a separate tort of lawful means conspiracy, but the claim is very specifically pleaded as unlawful means conspiracy. And there is no unlawful act identified by my client. And the only act identified is the receipt of the shares. And if you find, Your Honor, you find that there is no receipt of the shares, or there's no real prospect of proving that, then the case goes away. But separately, even if you were minded to proceed with the unlawful means conspiracy, which in my strong submission there is no basis for, the stop notice must go, because that is clearly predicated on the 3% shareholding being the property, or being arguably the property of Cayan. If it's not arguable that that 3% shareholding is transferred from Walnut and Ban Canada, then there is no basis for the stop notice, and there's no basis for the other causes of action. But as I will submit to you, what's being done by way of, and again, it's perfectly, I'm not suggesting it's improper, it just doesn't bear out. What's being done by way of the witness evidence from Hadef is to try and create an impression that is just not enough to make a real prospect of success. It's impressionistic. And when one looks at it forensically, there's actually nothing there to create a real prospect of success on the conspiracy case.
Yes.
You know, hopefully I've given you a strong kind of outline of what I'm going to say. So not much I'm going to say now is going to be a surprise. But just in terms of structure, I wanted to go through the relevant law, which is essentially in my skeleton, go through the background and how I've divided the case into 4 or 5 premises, which it appears Your Honor is well acquainted with. And then basically spend most of my time explaining why this premise of the share of transfer of the shares has no real prospects of success and therefore is ripe for immediate dismissal. And then I'll look at this point, Your Honour, you've just raised, whether the conspiracy case can still proceed even if there's no real prospect of establishing that the shares were transferred from Walnut and Bank Canada. With that structure in mind, if we can start with the relevant law, and this is pretty much quite fully set out in paragraph 11 onwards of Lane's skeleton. So I'll invite you to go to it. I don't know if you have a hard copy on or if you're working off.
I've printed it off.
Excellent. That makes it easier. So if we go to paragraph 11, which is internal page 5.
Yeah.
And so I've set out the rules for discharge of a stop notice. I also set out rule 4.16, which is to strike out a statement of case, and rule 24.1, which is immediate judgment. Your Honour will probably be aware that the more apt rule is really rule 24.1, because the point being raised in my skeleton is about whether or not there is a real prospect of success, and also whether there is any other reason to proceed to trial. If we look at paragraph 14, I've considered carefully your judgment, Your Honour, in the Bank of Saracen Alpen case, and I hope you'll see that this is not a kitchen sink application, that it is honed in on a particular factual allegation which we say is central to the case. I've also set out a paragraph 15, an important statement of the law of the DIFC Court of Appeal in Emirates Bank and Advanced Facilities Management, paragraph 33, and I'm just going to read it out. At the outset, we underline that, as already foreshadowed, the legal burden of proof rests on the claimants who seek immediate judgment to show that the defendants have no real prospect of successfully defending the claim. They refer to the Easy Air case. That said, it is not and cannot be for the claimants to conjure up the arguments which the defendants might advance to resist immediate judgment. Instead, an evidential burden rests on the defendants to raise matters capable of disclosing defences with a real prospect of successfully resisting the claim. To the extent that the claimants' contentions do not do so, the claimants will have satisfied the standard for immediate judgment without more ado. Conversely, to the extent that the defendants do meet the evidential burden, it is for the claimants to satisfy us that the potential defence has no prospect of success. We keep such considerations well in mind throughout. So I accept that Lane obviously has the burden of proof in its immediate judgment, immediate dismissal application under Rule 24. The only defence or the only basis for the claim is the transfer of shares. And the only basis for that is that alleged hearsay statement. And I will be submitting to you that even if you saw that hearsay statement as a self-standing reason to allow the matter to proceed, it simply has no prospect of success given the records that we have. I've then set out paragraph 16, Your Honour, the requirements to plead a claim in dishonesty, which you will be well aware of. So I'm not going to go through most of them unless there's something that you want me to raise. One thing I would, two of the items I would highlight, if we go to paragraph 20, citing Three Rivers case, per Lord Millet, per Lord.
Yes, Millet.
Yes. The second principle, which is quite distinct, is that an allegation of fraud or dishonesty must be sufficiently particularized, and this is the following bit is what I emphasize, and that particulars of facts which are consistent with honesty are not sufficient. And then he says, the second underlined bit, it is not open to the court to infer dishonesty from facts which have not been pleaded or from facts which have been pleaded but are consistent with honesty. There must be some fact which tilts the balance and justifies an inference of dishonesty, and this fact must be both pleaded and proved. Now, this is not particularly relevant to the issue of the transfer of shares, but it's when it's suggested that certain actions by the directors and signing documents, etc., which in themselves are perfectly lawful, are somehow enough to proceed with a conspiracy claim, it does become relevant, because there's nothing, to the extent they were relevant, they could be attributed to my client in the first place, there's nothing that tilts them towards dishonesty rather than the normal course of business. That's the first point. And the second point, this is actually more important to this issue of whether the shares were transferred. This is paragraph 22, where I say, equally, it is no defence to an application to strike out inadequately particularised pleading of fraud or dishonesty that some evidence may turn up before trial. And then I've quoted Her Honour Judge Melissa Clark in Mukhtar and Salim. Go over the page. Paragraph 69, the court is entitled to take into account further evidence which may realistically, I stress realistically, be available at trial. However, claims should not be allowed to proceed to trial based on a Macabrish speculation that something will turn up. And then I've quoted a paragraph 23, the DFC first instance decision in Bank of Singapore and Marge Holding Limited. This is the judgment of Justice Lemire. I'm not persuaded by those submissions. It is necessary for a party responding to an application for immediate judgment to put forward sufficient evidence to satisfy the court that it has a real prospect of succeeding at trial. If it wishes to rely on the likelihood that further evidence will be available at a trial, it must substantiate that assertion by describing, at least in general terms, the nature of the evidence, its source, and its relevance to the issues before the court. The court may then be able to see that there is substance in the point and that the defendants are not simply playing for time in the hope that something will turn up. It is not sufficient for a defendant simply to say that further evidence will or may be available. The defendants are entitled to confine their evidence to selected documents and general allegations, but having done so and having failed to show by evidence what other evidence can be expected to be available at trial, the court will not speculate about whether there might be any such evidence, and if so, what its nature might be. This is really important because in my submission, at its highest, the claimant is saying, well, we know we're only relying on a verbal hearsay statement made by Mr. Gubar to Mr. Al-Hatti in 2021, the making of which is denied, but there may be further documents that may, not even likely, that may show a transfer of shares either to Lane or to someone else. And even those documents are not identified. And we said that is not a basis to proceed to trial. So that, Your Honour, is my submissions on the relevant law, which I understand will be relatively uncontroversial. Just briefly on the background, Your Honour, are you comfortable with the different parties, or do you want me to run through those?
No, I don't think I need you to run through them.
Excellent. So if I can then just turn to, sorry, go on.
My only, I'd like a little bit more clarity about the different companies which have EFS in their title and those that have vision in their title, or did have vision in their title.
Yes.
I've tended to refer to the Jebel Ali company as M Corp, simply to make it easier to, rather than using EFS PGL or whatever it may be.
Yeah, I think that's quite helpful. So just taking the parties into the claimant Cayan was previously known as Jade. The first defendant, EFS Facilities Management, is the new DIFC company.
Yes.
To which the shares from M Corp were transferred. The second defendant, my client Lane, was formerly known as Vision.
Were they transferred?
So you recall that there was the company MCOR that you just mentioned.
Yes, but the question I have is, were the shares transferred? There's a resolution for the transfer, but there doesn't appear to have been a transfer, particularly from the claimant. And this one of the oddities about this case is that formal share transfers did appear to have been made. We have a
Yes.
resolution, we have common ground that there's a swap arrangement agreed, and thereafter, certainly in English and DIFC law terms, formalities are not observed in order to effect the swap arrangement as such. And that's one of the oddities that arises here, because
Yes,
Mr. Carr proceeded on the basis, it appears, that all had been transferred in accordance with the share purchase agreement. But as I see it, there haven't been actual transfers of shares either to EFS or indeed to Ban Canada and Walnut. I'm right about that, aren't I?
I can't speak for transfers to Ban Canada and Walnut. I think you're perfectly right that Cayan's case is that its shareholding in the MCOR entity should have been transferred to a shareholding in EFS, and that it was wrongly transferred in the name of Walnut and Ban Canada. And for the purposes of today, I take it as given that all of that has a real prospect of success. I've got to take that. So the only question, I'm sorry, when I was talking about it being the company that the new company and MCOR being the old company, was simply to set out the distinction between these parties. But you're right that there is a case put by Cayan that in fact its shares in MCOR should have led to an equivalent 3% shareholding in EFS. And for today's application, I'm assuming that that has a real prospect of success.
Yes, I understand that, and we'll focus in a moment on your much narrower point. But one of the difficulties about this case is that nothing gets formalized in the way that anybody expects it to be formalized, or any English or DIFC lawyer would expect it to be formalized.
I haven't. It's never been suggested that my client doesn't have the shareholding in EFS, the first defendant. I mean, that's the whole purpose of the stop notice. So I've not looked at the formalities of that. But if you want me to answer any of the questions in terms of the formalities of my client's shareholding in EFS, if it were challenged, then I'll make inquiries. But
that's not an issue, subject to the point we've discussed at the outset as to whether there have been other transfers.
So we have Cayan, formerly Jade, claimant, first defendant EFS, which is known as the DIFC company, which essentially, subject to formalities and subject to whether Cayan had a shareholding, acquired the shareholding of MCOR. So I'll call that MCOR. My client Lane, formerly known as Vision Investments. And then by the amended particulars of case, two more defendants are added. Mr. Tariq Taberi, who is a director of both the first and second defendant at different dates, and was also from March 2023 a director of Walnut and Ban Canada.
Yes,
that's the third defendant. Walnut and Ban Canada are companies that were incorporated in 2007 and 2010 respectively, and dissolved in August 2024. And then we have a fourth defendant, again added by way of amendment, who was a nominee shareholder and is a partner in the law firm Altamimian Company. So that's maybe all I need to say about the background. If I then turn to...
What about the other Vision company that your client has referred to? The Saudi Arabian company. What's that got to do with the price of eggs?
It doesn't. I mean, what the complaint that Ms. Basil seems to be making is that Mr. Tabari has acted oddly in his witness statement in not setting out the difference between the two. But that doesn't, I mean, whatever the ins and outs of that doesn't create any basis for a tort committed in 2019. I'm not sure what is being said about that, but maybe I'll wait. But
you say it's irrelevant.
Say again?
You say the Saudi company is not a relevant matter at all to this case.
No, and I don't understand how it can be irrelevant to the central issue, which is, was there a transfer of shares, or was there some kind of conspiracy in 2019 to deprive?
Mr. Tabari who first mentions it, that's all. But
Yes.
there it is.
And then,
all right, that's fine. As long as everybody agrees it's irrelevant, we can ignore it.
well, I'm not sure everyone agrees, but I'm struggling to understand the relevance. I just don't want to speak unfairly before my learned friend has had a chance to speak on that.
But there's a further EFS company, isn't there?
Yes, there's at least one, the one that had the shareholding that went away and that I identified. I'm not sure which other company you're talking about, Your Honour.
Well, that's the one I'm thinking of.
Yes.
But what I haven't grasped is how that's connected to the other companies. We've seen reference in the share register to it.
Okay, Your Honour. It's not something that I know off the top of my head, but I'll try and help you with that.
Okay.
So with that background in mind, if I can then just look at what I describe as in my skeleton as the 5 premises underlying the claims against Lane, and this is from paragraph 25 of Lane's skeleton.
Yes.
So the first 3, I mean, you can call them 3, for the first 3 premises which are not challenged, as right for immediate dismissal. In fact, I'm not sure they can be properly challenged. Cayan alleges that it transferred shares in the MCOR company to Walnut and Bancanada, but payment for those shares was not received. Yes. We don't know whether it was or wasn't, but I mean, I can't have that dismissed at this stage. It then says that because payment of those shares was not received by Cayan retained a beneficial interest in the shares allotted to Walnut and Bancanada in the first defendant. Yes. And further that the 4th defendant, Mr. Khan, should have been aware of that and should not have allowed those shares to be transferred, shares in the new company to be transferred to Walnut and Bancanada. You with me so far, Johan? I'm just trying to avoid going over.
Absolutely, I'm with you so far.
So we then get to the 4th, what I call the 4th premise, that sometime in September, the claimant avers, both in its stop application and in its substantive claim against Lane, that sometime in September 2019, the 3% shareholding in Walnut and Bancanada's name in EFS, the first defendant, was transferred to the second defendant, Lane. So we see this firstly in the claimant's evidence for the stop application at page 420 of the bundle. So it might be 421. This is Mr. Al-Hatti's.
Yeah, can you give me the paragraph number, because I did
paragraph.
Actually
yes, I'm so sorry. It's paragraph 7 of Mr. Al-Hatti's.
Thank you very much.
Statement, and he says in the last line of paragraph 7, I understand that the DFC Co shares held by Walnut and Bancanada was subsequently transferred onto Lane in or around September 2019, according to the DFC's public registry. And again, if we just pausing there, if we then look at the reference to the registry, which is in the bundle in my copy at page 560, 562, so 561 to 562. It's that same report on EFS facilities management.
Yeah, that's what we've just looked at earlier. Yeah.
And obviously, you'll see straight away, Your Honour, that doesn't show any transfer of shares from Walnut and Bancanada to Lane or to anyone. It does show on the last page that Walnut and Bancanada ceased to be shareholders on the 10th of September 2019. So that doesn't help Cayan's allegation. The only evidence that Mr. Al-Hatti then provides is if we go to page 420, 421, I beg your pardon. This is paragraph 11 of that statement.
Right. Yes.
He says, in relation to the transfer of the shares from Walnut and Bancanada to Lane, I was verbally informed in early 2021 by Mr. Chauhan, the CEO of the first defendant, and Mr. Rubar. Mr. Rubar was and I believe remains a group legal counsel for Javza Co., which is MCOR, and DIFC Co., which is the first defendant, that the shares were gifted by Walnut and Bancanada to Lane. If that is correct, and I have no reason to doubt the information given to me by Mr. Chauhan and Mr. Gobar, given the connection between Lane, Walnut, Bancanada and the Tabaris, the transfer of the shares in DIFC Co. to Lane was not an arm's length transaction with a bona fide third party purchasing the shares for fair value. Now, this is the only evidential basis for the transfer put forward by Lane, this alleged hearsay statement. And this is repeated if we go to the amended particulars of claim at paragraph 46. So in my bundle, that's at page 263. Paragraph 46.
Yeah.
So we see the factual allegation in or about September 2019, Walnut and Bancanada transferred to Lane the shares in EFS that had wrongly been transferred to them by Mr. Khan. Accordingly, Lane is currently the holder of the shares in EFS that ought to have been transferred to Cayan. Pending disclosure, Cayan is unaware of the precise terms by which the shares were transferred from Walnut and Bancanada to Lane. And then the only basis for this is pleaded at 47. In or around early 2021, the claimant was verbally informed by Mr. Guber and Mr. Chauhan that the shares in EFS held respectively by Walnut and Bancanada were gifted to Lane. In the circumstances, the transfer of the shares in EFS by Walnut and Bancanada to Lane was not an arm's length transaction with a bona fide third party purchasing the shares at value. So that's the only basis. You'll also see tellingly, Your Honour, that by way of amendment, paragraph 48 and 49 are added to the particulars of claim, which actually plead an alternative version of facts and a very central factual premise. It says, alternatively, on or about 10th September 2019, Walnut and Bancanada transferred the shares it held at EFS.
Yeah.
And then it says at paragraph 49, notwithstanding the information provided by Mr. Gober and Mr. Chauhan, if Walnut and Bancanada did not transfer the shares to Lane, the identity of the recipients currently remains unclear. Cayan reserves the right to plead further to the transfer of shares in EFS by Walnut and Bancanada upon receipt of further information and or disclosure. We just pause for a second. There's an alleged verbal statement in 2021. There's no record, there's no particulars of the context in which this was said. There is no written record or contemporaneous note produced from Mr. Al-Hatti that this was said to him. And in 2021, no one from Cayan wrote to Lane or anyone else saying, why had these shares been transferred to Lane? This conversation is not mentioned till several years later. And the way it's first mentioned, if we go to what should be page 554, it's a letter from Cayan's previous lawyers on the 23rd of April, 2024. ADG Legal. You might have it 555, Your Honour. It's a letter on the 23rd of April, 2024.
Yeah, got it. 555, yes.
And if we see how it's described here, at paragraph 5, this is 23rd of April 2024, written by lawyers. Notwithstanding the nominee did not transfer the equivalent shares in EFML to our client as required by the SSA, our client is led to understand that the nominee instead transferred those shares to one or more entities owned or controlled by one of EFML's founding directors, Mr. Khaldoon Tabari, who was also the ultimate beneficial owner of the majority shareholder of EFSGL. This is nothing like the specific hearsay statement pleaded in the appendix amended particulars of claim, which is, we were told they've gone to Lane. they've been gifted to Lane. There's no explanation for why this very specific allegation is stated very differently here in vague terms. It's gone to one or more entities controlled by Mr. Khaldun Tabari. And then similarly, if we go to page 557 in my bundle, it might be 558 in yours, Your Honour. It's a letter on the 21st of May, 2024, again written by lawyers. Do you have it, the 21st of May letter, Your Honour?
Yes, yes. Okay.
Now, again, you'll note straight away that it's actually addressed to Mr. Gubar, the alleged maker of the hearsay statement. And they don't say, you told us, you told Mr. Al-Hati XYZ. What they say, again, is this very different statement, paragraph 5. Our client is led to understand that the nominee instead transferred those shares to one or more entities owned or controlled by one of EFML's founding directors, Mr. Khaldun Tabari, who was also the ultimate beneficial owner of the majority shareholder of EFSGL. So even if there had been, I mean, we say that a hearsay statement is not a grounds for constituting a real prospect of success. But even if we're here dealing with whether or not there was such a statement, if there was a statement in 21 that Gubar said to Al-Hati, the shares have been gifted to Lane, why on earth isn't that being said in terms in 2024 in a lawyer's letter? We then have, obviously, on the record, Mr. Gubar denies making such a statement. So what we see, if we go to, it's 334 in my bundle, Your Honour. It's a letter on the 28th of January 2025 from Hadef to Clydes, who are the first defendant's lawyers. So you might have it at 335, I apologise. It's the 28th of January 2025 letter.
Yep.
Paragraph 3 says the first defendant will know through the correspondence between the parties and the DIFC court registry that the second defendant also filed an application seeking to discharge the stop notice issued by the DFC court. And then it says a few lines down, the second defendant alleges that it did not receive the disputed shares from Walnut and Ban Canada by way of a gift or otherwise. This position is supposedly supported by historic share register documents for the first defendant. The claimant's position in respect of the discharge application is expressly reserved. However, it is noted that the second defendant's position is in contradiction of what the claimant has been told by the first defendant as pleaded in paragraph 41 of the particulars of claim. That alleged conversation in 2021. They then say, paragraph 7, the claimant requests that the first defendant urgently provides the following information, and then we go over the page at F. If the position articulated in the second defendant's strikeout application is correct vis-a-vis the information provided to the claimant by the first defendant, what was the basis for the first defendant's representation to the claimant that the disputed shares had been gifted to the second defendant? So they're asking, well, we've alleged that Mr. Gubar told Mr. Al-Hati that there's been a gift of the shares. Why did you say this? And then we see the response from Clyde at the next page. This is the letter on the 6th of February, 2025. You have that, Your Honour?
Yes.
And they refer to paragraph 41. Paragraph 41 of the POC alleges in or around early 2021, the claimant was verbally informed by Mr. Gubar and Mr. Chauhan that the shares in the first defendant held respectively by Walnut and Ban Canada were gifted to the second defendant. We immediately point out that the allegation is framed in vague, general and unparticularized language, is unsupported by any documentary evidence, does not specify which representative of the claimant was allegedly so informed. Now Mr. Al-Hati says he was a person. Does not specify where the alleged discussion took place. Does not specify the precise date on when the alleged discussion took place. And then in paragraph 7, they say, in the first defendant's statement of defense delivered on 30th January 2025, the first defendant specifically denies the claimant's allegation in paragraph 41 of the POC. The statement of truth accompanying EFS's defense has been confirmed by Mr. Gubar. The premise of your letter is thus based on an unproven, unsubstantiated, and unparticularized claim that is not supported by any evidence, which claim is in any event denied by the first defendant, and B, an apparent and self-serving inference that the claimant wishes to draw based on its own unproven, unsubstantiated, and unparticularized claim. So just pausing at the evidence of the transfer from Cayan, we say it's incontrovertible that the only evidence is this alleged verbal hearsay statement. 1. 2, the alleged verbal hearsay statement is described in vague terms in terms of the context of the conversation. Is why in 2021 were they told, and when, and why is there no record of this, and why is there no action taken thereafter, saying right into lane, for instance, so on. And then we see that in 2024, when their lawyers write quite carefully, including to Mr. Guba themselves, there is no mention of this hearsay statement. It's just said that there's an understanding that the shares have gone to one or more entities controlled by Mr. Khaldan Tabari. And finally, obviously, not only are they relying on an alleged hearsay statement, the maker of one of the makers of the alleged hearsay statement, Mr. Guba, has signed a statement of truth for defense saying he never said this. And the other maker, Mr. Chauhan, is not offered as a witness. So even if the alleged hearsay statement was a basis for the case proceeding, we say that it's not made out. But even if it were, let's say that Mr. Goba said, yes, I did say this. That's not enough to allow a claim of dishonesty to proceed, given what else we know. So we then turn, Your Honour, to what we do know about the shareholding. So the first point is that we have a limited point of inquiry. We know it's common ground that on the 10th of September 2019, Walnut and Bancanada's shareholding ceased in EFS. That's common ground. It is also common ground that on bear with me, I want to get my dates right. As of the 25th of April 2019, that's the first share register, Walnut and Bancanada's shareholding is extant. So the question then is, when is a point of inquiry for an alleged share transfer? Is sometime between the 25th of April 2019 and the 10th of September 2019. So what we say is that the documentary record shows that the 21% shareholding that Lane held on the 25th of April 2019, when nothing bad is said to have happened in terms of when no transfer is alleged to have taken place, did not increase in the manner suggested. It went up slightly and then it went down, and both of those items can be explained. So, do you need me to explain to you how we get to the 21%? I'm not sure it's particularly relevant, given that it's accepted that we.
I've been through all those documents. I've seen what the shareholding register says.
Okay, so if we start with the 21% shareholding, so we go to the shareholder register at 749. I beg your pardon, Your Honor, it might be, it's one we just looked at. It might be a different page on yours, 750 perhaps.
Yeah.
So we see at the second page, we see the Vision Investment and holdings 21%, 10,500 shares. Yes, Your Honor?
Yes.
And then we see over the page, we see Walnut 11.75% and Bancanada 11.50%. Yes. And then we see, if we go to page 725, and again, this might be different. I'm looking inside Mr. Tabari's witness statement, paragraph 20. you have paragraph 20?
Yeah.
So it says, on or around the 14th of May 2019, D1 increased its share capital and issued new shares from 50,000 to 55,530 shares. Pursuant to this, D2 Lane subscribed additional 1 to 60 shares, increasing D2's shareholding in D1 from 21% to 21.18%, a very modest increase. And the documents for this are at 7.5. It's Exhibit L7, which is a share subscription form. (758) in my document. Do you have that, Your Honour? It might be 759 in yours.
Yeah.
So you see the subscription 1,260, and if you go up to the previous exhibit, which is Exhibit L6, starting at 753 in my bundle, it might be 754 in yours.
Yes.
You see the shareholders' resolution approving an increase in share capital.
Yes.
So that's a very modest increase from 21% when everything is said to be kosher, no transfer, and then 21.18%. And then if we return to Mr. Tabari's witness statement of 725, paragraph 21 I'm looking at.
Yes.
He says in paragraph 21, on or around the 27th of July 2019, Lane sold 1912 number of EFS shares, equivalent of 3.44% of shareholding to Akrima Afani. And following the disposal, D2 shareholding reduced to 17.74%. And that's where we remained in the 24th of September register. And we see this transfer of shares documented. If we go to page 761 in my bundle, might be 762 in yours, Your Honour.
Yeah.
And then if we go to the next exhibit, which is a couple of pages down, we come to that register we looked at.
Yeah.
Which is the register issued on the 24th of September 2019. And you'll see it's got a stamp from the registrar of companies and so on. And if we go to the second page, we'll see Lane has 17.74%. It's common ground that Walnut and Bancanada no longer are shareholders. And you've seen my point, Your Honour, at the last entry in the share register that there's a new Kuwait company with a 43% shareholding set to be acquired on 10th September 2019. That seems to be an obvious point of inquiry for where the shares went to. I can't say any more than that, but that's quite evident from the face comparing the two registers.
And who are Vision International Investment Co. at page 765, last line, who have 3.6%?
My understanding, they are a different company from Lane, which used to be called Vision Investment and Holdings.
Yes.
I don't know what their directorship is. But as you'll see on it, if the suggestion is somehow being made that the 3.60 is acquired from Lane, Lane can account for how its shareholding went from 21% to 17.74%. I've just taken you through that.
Yes.
So we say that it is clear that to the extent the burden of proof is on my client for the purposes of this application, that the documentary record does not show there was a transfer from Walnut and Bancanada to my client. In fact, the documentary record shows in every stage the movement of shares, the shareholding, and what would need to be shown to resist this application is that there is a real prospect of establishing that sometime between April and September 2019 there was a movement of 3% of shares from Walnut and Bancanada to Lane, the second defendant. And that's simply not borne out by the records we have, and it's certainly not made good by this hearsay statement. So what we're left with then, if we go to the claimant skeleton at paragraph 43.3, this is internal page 23.
I'm sorry, I didn't get that reference. To
It's
what?
claimant skeleton at paragraph 43.3.
Yes.
Lane is in effect is inviting the court to conduct a mini trial on the barest of evidence. By contrast, if the claim is allowed to proceed to trial, as Cayan says it should, there is likely to be disclosure of much more documentation relating to the share swap and the dealings in the shares. In that regard, it is important to bear in mind that on its case, Cayan has been the victim of dishonesty. Unlike the defendants, and again, I submit that it's not fair to ally defendants plural with Lane. Unlike the defendants, Cayan does not have access to documents which would fully explain what happened to the shares or confirm the links between Lane, Walnut and Bancanada and the Tabari family. As submitted above, that is not for want of trying. Cayan has requested information and documents from EFS and Lane, but they have failed to cooperate. I'll look at that request in a moment. If we go back to 43.3, it's not being suggested that there is a likely specific document or category of documents that the court can reasonably assume will show a transfer to Lane. At its highest, it's being suggested that there may be documents that may provide more detail of what happened to Walnut and Bancanada's shares. At its highest, the claimant is agnostic as to what they will show, whether they will show that the shares went to Lane or not. There's nothing that the claimant is able to point to that could probably support its case. Now, it's been suggested that there was a request to Lane that was unreasonably not complied with. If we look at that request, it's a letter in the bundle, in my reference, of 1090. It might be 1091, Your Honour, in your. It's a letter of the 14th of April 2025. So it's. You have
Sorry,
it,
page again.
1090, possibly 1091, Your Honour. It's 14th of April 2025.
Yes, got it.
And then if we go to the actual request, which is next page, paragraph 7 at the bottom of the page, so that the claimant can consider the position put forward by the second defendant in the consolidated applications, the second defendant is requested to urgently A, provide a comprehensive and detailed record of all is underlined, share transactions maintained in EFS's registry since inception. This request encompasses, but is not limited to, transfers, allotments, and assignment of shares, with particular emphasis on the disputed shares to verify their status and transfer history. Such information documents are within the custody and or control of Lane by virtue of his shareholding in EFS. The claimant expressly reserves a right to require further documentation as necessary to fully investigate the matter. Just let's take this at face value. It's asking for a comprehensive and detailed record of all share transactions maintained in EFS's registry since its inception. There's no explanation for that. On Lane's own case, on Cayan's own case, the only taking the widest time frame we are concerned with, is April 2019 to September 2019. And even then, we're not concerned with the claim against Lane or share transaction in EFS. It's simply shares received by Lane. What is clear from the wording of this is that this 7A is a way for Cayan to find out who received the shares and to do an overall fishing expedition. It's not for finding a document that is reasonably believed to exist that will show a transfer to Lane. Lane has provided the share registers that it has in that period, and it has provided a clear account of the movements of its shareholding in that period, April to September 2019. It cannot provide something that, I'm not sure what it's meant to provide. Is it meant to prove a negative? Is it meant to provide a ground for Cayan to investigate who else it can sue? That's not Lane's job. It's something that Cayan.
What does Mr. Tabari say he's produced? I'm looking at his first witness statement and paragraph 17 through to 22, which I think is all there is.
So he says, so obviously Mr. Tabari's statement, I think, let me just double check, is before this this letter of request. So he has provided what he understands to be the relevant movement of the shares.
Well, all he does, as far as I can see, is to talk about the specific transfers that you have mentioned and produce what he says is the share register in relation to that.
Yes. But
So,
my understanding on instruction is that my client does not have any other share register documents issued to it for this period. The April one followed by the September one. The rest that we have are for later periods, later years.
yeah, but he exhibits L9, that which is issued on the 25th of April. He exhibits then shareholders' resolution, share subscription for the increase in capital, and then the register of shareholders of 24th of September 2019 at L13. So he doesn't say that a full record has been produced, does he?
Sorry, I'm just trying to be careful. A full record of what?
Well, of the share registry. EFS mustn't it, a share registry which records all the transactions between shareholders.
Yes.
Well,
sorry.
Nobody has produced that.
We have not been asked to produce a share registry between April and September 2019. We've been asked to produce every possible record of any movement of EFS's shares. That's obviously not within our gift in 2025, nor should it be something that we should be required to do. What we have done is produce the share registers that we have for this period, which are these two. These are the only two that we have. There's nothing that we withheld that is in my client's possession, and I can confirm that on instruction. And then we've said that the movement from 21% to 17.7% is based on these two transactions. Here's a document showing two transactions. One goes slightly up and then one goes down by about 3%. So in terms of being said, well, why haven't you provided further? We don't need to prove to Cayan where Walnut and Ban Canada's shares ended up. That's not something we need to show. What we need to show is that we didn't receive them, or there's no real prospect of establishing that we didn't receive them. And there's no document identified that we are said to have that would show that will be relevant to whether or not we receive them. I'm not sure what it is that we were actually asked to produce. If the point is it would be nice for Cayan to have access to a daily register, it might be nice for them, but that only goes to them doing their fact finding as to where these shares have ended up. It doesn't go to whether we've received them. We've given a full account of our shareholding in EFS, as far as we understand, for that period. What I'll also add, Your Honour, is that in a way we're almost going back to front. A stop notice was sought, a claim was issued based on a verbal hearsay statement. If there was some important fact finding that was needed, surely that should have been done before a claim was pleaded in dishonesty against my client, not going along the way. The fact finding is aimed at EFS, the first defendant, but there's nothing that the claimant is able to point to which suggests that it is more probable or realistically arguable that the shares ended up with my client. There's nothing they pointed to other than this verbal hearsay statement. And we've been able to account for our shares. It's for them to then say, well, what is the evidence they rely upon for the transfer? They can't keep saying, well, you got to give us another document which may or may not show who the transfers went to. I can see Your Honour would want, as the judge managing this case, to get that information to decide who the shares went to. That doesn't answer an application from my client, which can only be met with a real prospect of showing that the shares went to my client. And there is no specific request to my client that it has been shown not to comply with. The only request made is so general that it's clearly irrelevant. I'm not sure. Do you need me to, I'm just conscious of the time. Do you need me to address you on this issue of the transfers anymore?
Well, you better say whatever you want to say, Mr. Hussain.
So that in my submission shows that there is no real prospect of Cayan establishing that the shares from Walnut and Bancanada were transferred to Lane. And then if I can then just look at the effect of that, and that's in the skeleton Lane skeleton, paragraph 48 onwards, Your Honour.
Yeah.
So I think the starting point is, if there is no real prospect of establishing that the shares from Walnut and Bancanada were transferred to Lane, then clearly there is no basis for the stop notice. The stop notice is a claim predicated on Lane having a beneficial interest in the securities. The securities are Lane's shareholding. The only basis for the beneficial interest is if they came via Walnut and Bancanada. So it's clearly relevant to discharging the stop notice. It's fatal to the stop notice. One point of nuance I would raise is that although the test for dismissal is no prospects of success, in my submission, there is no set bar for varying the stop notice. And in my submission, given the stark nature of the impact of a stop notice, the bar should be much more generous to Lane, and the test should be that you need to be satisfied that there is a good case, that there is a beneficial interest in the shares, and that certainly is not made out. So the stop notice should be discharged in my submission, even if the bar for immediate dismissal is not met. I'm not sure if I'm articulating the point I'm making clearly, Your Honour.
Well, I think I've got the point. I'm just going to have a look at the rules.
So for my reading, the rules is simply accommodate an application to discharge or vary, but there's no test as such.
No.
But I would say that it would be, obviously it's a matter for your discretion, but it would be wrong to, in my case, certainly on these facts, to apply the higher test under Rule 24.1. Then in terms of the substantive claims, if we look at the paragraph 50 of Lane's skeleton, there are four.
Sorry, just a moment, Mr. Hussain. I'm just looking at Rule 46 relating to stop notices.
Yes.
So 46.43 gives the court power to respond to a request, and the details required for such request are in 46.44. And 46.45 simply gives the criteria, and if the court considers the request complies with 46.44, it will issue. Then it gives the effect to the stop notice, and the only point on discharge or variation is 46.53 and 46.54. And just says may make an order of discharging or varying. So one assumes that if this is being done on an interlocutory basis, one's simply looking at an arguable case. So it's not going to be very different, is it, from the summary judgment position? If we're in a trial, then of course the court would have to come to conclusion whether or not the stop notice, the interest had been established. But if you're dealing with it on an interlocutory basis, it presumably has to be much the same as a summary judgment position. Do you accept that or not?
You're right. It's certainly a point that I was thinking about. I don't think that's the correct way. I'm just, firstly, because it doesn't set it. There's no bar set. But sure. I accept that it's entirely a matter for the court what it does. But I would suggest, I would argue, that it would be harsh on the party receiving the notice if all that was required to put a stop to its use of its property was a arguable case that the property may belong to someone else. It should at least be a reasonably good case or a reasonably arguable case rather than a realistic case, which obviously is a very low threshold. Otherwise, the ambit for people being stopped from using their property on what the court recognises is at best a weak, yet not unrealistic basis would be quite draconian in my submission. So at the most, I'd say it's a matter for your discretion.
Yes.
What you take as a test.
There's no evidence before the court that Lane wishes to dispose of its interest. Is there?
I think Lane has said that this is an interference with his rights. I'll have to look at whether there's any specific evidence.
My recollection is that the claimant says somewhere it's afraid that that Lane may want to do that, but I don't think Lane has said anywhere in its evidence that it has any intention of disposing of its interest.
Not at the moment, no. Not that I'm aware of. Those instructing me will correct me, but we still submit that it's quite we have no control. This is a multi-party case. We don't know when it's going to be resolved. It's at the moment a bit of an open-ended
yes,
stick on us. So I mean, I think you have my simple point that the test is not set at real prospects of success for the stop notice to be removed. And then if we look at the substantive claims, Joran, I'm just conscious of the time. We go to the amended. So if you hold my skeleton of paragraph 50, and then we can go to the amended particulars of claim. It's 270, I believe. The first cause of action is paragraph 60 of the amended particulars of claim. The first cause of action is in knowing receipt.
Yes.
So obviously, if there's no realistic prospect of showing receipt, then that cause of action must go. Then the second cause of action is at paragraph 74 onwards. Which is basically receipt under a mistake. But again, that requires receipt. So if there's no real prospect of showing the transfer, then that goes. The third cause of action is at paragraph 78, which is unjust enrichment. And that, again, at paragraph 78, avers that Lane acquired the shares from Walnut Bank Canada. Again, that goes. And then finally, we have the paragraph 112. So 112, yes, the unlawful means conspiracy allegation, cause of action.
Yeah.
And if we look here for a moment, there's an agreement or combination averred. And then if we go to 114, the unlawful means used, paragraph
112.1 and 2 comes first, which involves procuring the transfer of shares to Walnut and Bank Canada and then to Lane.
Yes.
Right. So it's there are two elements to that.
Yes.
I'm sorry, you were taking me to which paragraph?
Yes. So I'm so sorry. You actually taken a point that I missed. That the actual agreement involves a conspiracy to have the shares transferred to Lane, and then if we go to 114,
yeah,
the unlawful means we have at 114.1. The procured were aware of, assisted and facilitating Mr. Khan's breach of duties as trustees in transferring the shares to Walnut and Bank Canada instead of Cayan, as he should have done. Then they say Cayan repeats paragraphs 50 to 53 and 58 and 60 to 63 above. So if we go back 50 to 53, sorry, we're going to have to scroll up. So it's, bear with me.
but it's the same point, isn't it, that I've just made in relation to 112.1, 112.2. There are two elements. The first is the breach of duty, assisting in the breach of duty in transferring the shares to Walnut and Bank Canada. And then secondly, in 1142, it's Lane receiving and retaining them. So there are two elements to the conspiracy.
Yes, and then
one
sorry, go on.
One is to get them to Walnut and Bank Canada, who are said to be Tabari-related companies in some way. And the second is that Lane actually gets them.
Yes, and then if we look at the unlawful act, they refer to 114.1, they refer back to paragraph 63 with reference to Lane, which is a 272 in my bundle. That again is just simply the receipt. So it doesn't refer to any other action other than receiving the funds.
Well, 50 to 53 is Khan's breach,
yes,
isn't it?
So that's not relevant. And then if we go to
it is relevant because they're saying that there was a combination, a conspiracy in which Lane were involved to facilitate Khan's breach.
Yes, but they don't say what action Lane took, other than saying, I mean, that's just a mere assertion, but the action they're said to have taken, and the unlawful act they're said to have undertaken. If we go to paragraph 63 through 66.
60 to 63 is the connection between Lane and Walnut and Bank Canada, isn't it?
Yes. And then 63 to 66 is the action, and the only action they talk about is receiving the shares.
Sorry, which paragraphs?
63, 64, 65,
Yes.
66. So if we go back to 114,
Yes.
114.1, they refer to, oh yeah, so you're right, you're on 60 to 63.
Yeah.
And then 114.2 is talking about receiving the shares.
Yeah. Yeah.
And then in terms of instructing Mr. Khan, that's only an allegation against EFS. And in terms of inducing Mr. Khan to breach the agreement, that's only an allegation against EFS. So the only unlawful act pleaded is the receipt of the shares.
Well, that's not right, is it? The agreement is to make Mr. Khan breach his duty. So that's
Yes,
the
I take your point, Your Honor, but there is no...
or not there's a factual basis for it, it's another question, but that's the allegation.
Yes, Your Honor, but if we go back to... I'm so sorry.
Go on.
Give me a moment. If we go to 60 to 63, that's the
Yes.
only reference I give for procuring Mr. Khan to do something. They say Lane is and or was ultimately owned and controlled by Khaldoon and Zaina Tabari and all the Lane directors. Walnut and Van Canada had been controlled by various people, it's alleged. And then they say it is inferred from the very fact of the transfer of the shares in EFS to Walnut and Van Canada and then to Lane, that Walnut and Van Canada was used as corporate vehicles to acquire the shares in EFS for the benefit of Lane and or ultimately. So it's just a circular argument. It's just going back and the inference of the attempts. I mean, you have my point that there's no evidence or no factual basis for the allegation, other than both a conspiracy to receive the shares and an actual receipt of the shares.
Mm-hmm.
So in my submission, you also note, Your Honour, that there is a kind of pivot in the responsive evidence, which doesn't match the pleader case from Cayan, because they then start talking about, well, if you didn't have a legal interest, as in if there wasn't a transfer of the shares from Walnut and Bancanata to you, you might have a beneficial interest. That's not a pleader case, and there's no cause of action established in that. So then what we have in Ms. Fazl's witness statement are various actions by essentially members of the Tabari family in signing documents and so on, which are said to allow a way to sustain the claim. And as I've said in my annex, that doesn't sustain the claims if there was no transfer. And in fact, there's nothing in those actions that is unlawful or more consistent with an inference of dishonesty rather than an honesty. And I've tried to break them down. I don't want to go through them because there's about 14 of them, but I think it's quite self-evident. What I've said, what I do want to point out is that even if these had been unlawful acts by the directors, there's a logical leap without any pleaded basis for it, that these people were acting as agents of the company, limited company called Lane, in undertaking these actions. That's not even pleaded. That's just an impression that that's sought to be given. If you look at paragraph 58 of a Lane skeleton, I've quoted from Emirates Bank and Advanced Facilities Management, and the DFC Court for Appeal of paragraph 35. And it says, first, we are satisfied that no factual basis has been identified for the defendants to contend with any realistic prospect of success that Nordbank was acting on behalf of the other claimants. At the 16th December meeting, we agree with the judge's forthright conclusions. The defendant's bare pleading in this regard is plainly deficient, but the difficulty goes beyond a matter of pleadings which might otherwise have been capable of remedial amendment. As Justice Roger Giles concisely expressed it in First Round Property Holding versus Damac Park Towers, agency is a legal construct, not a fact, but a conclusion from facts. Here, the defendants have failed to advance any factual allegation from which the court could properly conclude or infer that there was an agency relationship between Nordbank and the other claimants. This conclusion is itself fatal to ground one of the appeal, but we do not leave matters there. And then, obviously, I've quoted from Supreme Court judgment in Singularis Holdings Limited and Daiwa Capital Markets. Understandably, this is a case in different facts. That case referred to whether the negligence or dishonesty of an innocent company could be held against it as contributing to its own loss. So the case isn't on all fours with R1. But the point being taken in that case is that it's not a given, even where a director is a sole controlling mind of a company, that his actions, his or her actions, are automatically to be attributed to the company. And I'm just going to do this very briefly. We've got a 1183, which is a table. You'll see in the second column the text of paragraph 30 of Ms. Fazol.
What's your reference there?
It should be 1183. It's the annex to the skeleton.
Oh, right, sorry.
So you'll see the text of Ms. Fazol's statement. Again, I'm not suggesting for a moment that this is in any way improper. It's obviously a case being advanced very properly for Cayan, but it doesn't substantiate or make good a realistic prospect of success for the claims. So what you see, as I said, well, the director signed a particular document. Well, that's not an unlawful act in itself, and nor is it connected to Lane or to the loss cause. These people in each case were also directors of other entities. There's no basis to suggest that they took these actions in their role as directors of Lane. And I'll leave you to go through that, Your Honour. I'm not sure it's a great use of your time for me to go through those 14 points. The only last point I want to deal with is, I think in Ms. Fazol's heard witness statements at page 1019 in my bundle, it's paragraph 33. Other compelling reason for trial is the headline.
Yeah, got it.
Again, in fairness, I don't think this is a point pursued, at least strongly, in my learned friend Skeleton. But if Your Honour, you found that there was no real prospect of establishing the claims, then it is not a reason to proceed to trial against Lane that the claims against the other entities are still proceeding. And that's the antithesis of what the court is required to do in my submission, particularly with regards to claims of dishonesty. They must be carefully looked at, and if there is not a real prospect of success, then they do not proceed. Your Honour, unless I can assist you further.
No, thank you very much indeed. Thank you.
I'll turn my mic off.
Mr. Riley, does it make sense to have a short break at this point, just for 5 minutes?
Your Honour, it does, not least because you may have noticed I'm having some issues with my camera. So if I could have 5 minutes to try and resolve those, that I'd be very grateful.
All right. Well, if I say 10 minutes, that will enable me to get a cup of coffee. So
very good.
10 minutes will take us to about 20 minutes to the hour or thereabouts.
Very good.
Your Honour, apologies for being late.
That's all right. Don't worry. I don't think you are late. Yes, Mr. Riley.
Your Honour, thank you. Your Honour, before I get into the meat of Malone and Friends submissions, I just want to make some introductory submissions myself. Firstly, this is, of course, what can be described as a hybrid application because it proceeds on the basis of both RDC Rule 4.16 and Rule 24.1. So, and that is expressly set out in the application and in the draft order in support of it. So there are potentially two limbs to this application, one being strikeout, one being for immediate judgment. Now,
Well,
there is
Mr. Hussain has essentially accepted that this is a summary judgment, immediate to judgment application because he bases it simply on the absence of any factual basis for the fourth premise, as he puts it. So I don't think you need to deal with this on the basis of a strikeout on a point of law, so to speak, or an unpleaded case. At least that's, if Mr. Hussain wants to say anything different, I'm sure he will, but that's my understanding. And the stop point is slightly different because there's no particular test, but I'm approaching this on the basis that because this is interlocutory, I have to deal with the stop notice on a similar footing as to whether or not there is either a good arguable case or whatever the appropriate test might be for summary proceedings.
Your Honour, yes, Your Honour, just dealing, if I can just come back to Your Honour, just on those 2 points in reverse order. So far as the stop notice test is concerned, yes. My submission is Your Lordship is entirely right to approach it on the basis of real prospect of success or good arguable case or real issue to be tried. There are nuances around those tests, obviously, but in the round they come to the same thing. Is there a good arguable case presented in relation to the receipt, what I would call the receipt claims, and if so, then in those circumstances the stop notice should stand. That's appropriate, not least because, putting aside the question of the relevant test, the only basis on which the stop notice application is advanced is on the basis that there is no real prospect of success in relation to the receipt claims. So the only ground you have to deal with essentially on the stop notice application is mirrors Malone and Friends' argument in relation to the strikeout application.
Yes.
Then, in relation to the strikeout application, my submission, it's not simply a question of a real prospect of success on the question of receipt. That's as far as it goes in relation to the summary judgment application on the receipt-based claims. Sorry, Your Honour, I'm still having problems with my camera, so I will try and come back to you as soon as I can. But so far as the unlawful means conspiracy case is concerned, I think it goes a little further than that, because Malone and Friends says, well, there's no arguable case on receipt, but he then goes on to say that putting that aside, if you look at the contents of the pleaded case, there's no disclosed cause of action, and he refers in his skeleton to, for example, an absence of other unlawful means conducted by Lane. So there's an additional point which properly in my submission is a strikeout argument, and I will come to that obviously in due course. So far as those criticisms are concerned with the pleading, it's twofold actually. It's not only is there's no particulars of unlawful conduct by Lane, but also it's the criticism is that there's no pleaded particulars as to why the conduct of Lane's directors should be attributed to Lane. And that's the point that my learned friend was dealing with at the end of his submissions, and which he addresses in his skeleton argument at paragraphs 55 to 60. Now, for reasons I'll develop in due course, those criticisms strikeout criticisms in relation to the unlawful means conspiracy, we say are bad in law and are not a fair analysis of the pleaded case. But I'll come on to unlawful means conspiracy after I've dealt with the receipt-based claims. Now, your lordship, your honour will have seen how we set out the knowing receipt claim. We plead the very close links between Lane, EFS, and Walnut and Bank Canada. We set out the transfer, the pleaded transfer of the shares to Walnut and Bank Canada and then on to Lane. And in particular, at paragraph 46, that's where we allege that the shares were transferred from Walnut and Bank Canada to Lane. So there is a pleading there as to that transfer. You will have seen that we allege that there's a breach of trust and fiduciary duty by Mr. Khan. And then we get into the various causes of action. In relation to Lane, there are obviously two causes of action. The first one is knowing receipt, which is dealt with in paragraph 60 to 63 of the amended particulars of claim. And then there are two other receipt-based claims. There's mistake. We say in summary that there were by mistake of fact and law that the shares were transferred to Walnut and Bank Canada and then to Lane, and so they're held on constructive trust. And then we also allege unjust enrichment based on the receipt of the shares.
Yeah.
Now, so far as the relief we seek is concerned, in paragraph 64, we allege that the shares transferred by Walnut and Bank Canada to Lane are held on constructive trust, and so Lane is liable to account in equity. And there in the prayer, various items of relief are sought. We seek declaratory relief in relation to the shares being held on trust, and also the proceeds of the shares being held on trust. We seek orders that Lane transfer shares representing 3% of the shares to Cayan. And then importantly, we also seek tracing relief. We seek orders for the tracing of the shares. And I'll come on to why that is. I emphasize that particular point in due course. So dealing with, first of all, the application for immediate judgment in relation to the receipt-based claims, the only point that is made by Lane in relation to this application is that there's no real prospect of success of the receipt claims because Lane says it did not in fact receive the shares. And to summarize the argument, Lane says that by the time of the share swap, it had acquired 21% of the shareholding in MCOR. So it was entitled to 21% of the shares in EFS under the share swap. It says that Walnut and Bank Canada were entitled to 11.75 and 11.5% of the shares in EFS respectively. And then Lane points to the two shareholding registers, one dated the 25th of April 2019, which is at page 751, and one dated the 24th September 2019, which is at 763. And then on top of that, it refers to the various share transactions which Mr. Tarek Tabari described in his witness statement. Lane says that it increased its share capital after the share swap to 21.18%. And it says it did that in around May 2019. So there is, just pausing there, there's an acknowledgement that it did increase its shareholding from the 21%. And we'll come on to the evidence in relation to that. And then Lane says that it sold, later on in 2019, it sold about 1,900 shares, roughly 3.4% of its shareholding, to someone called Akrima Afani, a Jordanian, reducing its shareholding, therefore, to 17.74%. And so its argument is, well, as a matter of maths, because you get to September 2019 and you can see that Lane holds a lesser percentage of the shareholding, namely 17.74%, compared with the shareholding percentage it held in April 2019. Ergo, it says it couldn't have received the shares from Warnock and Bank Canada. And I'm going to come on to now submit why that is factually wrong when looking at the real prospect of success. But first of all, I'm going to deal with the key point, which is that contrary to Lane's submission, the evidence that Lane relies upon does not establish that Cayan has no real prospect of success in showing that Lane received the shares. And your lordship has already described the first point as the lacuna, because we have the two shareholder registers only, which provide a limited snapshot of the makeup of the EFS shareholders at 2 points in time in 2019, some 5 months apart. And as Your Honour will be aware, in DIFC companies have an obligation to maintain a continuous shareholding registry. So there will be a continuation of the shareholder registers, which demonstrates the constituency of the EFS shareholders. Now, because there is a lacuna, those two shareholder registers provide no information regarding the ownership and the transfers of shares in the 5-month interim period between the two shareholder register entries. And as I outlined just a moment ago, Lane acknowledges that between April and September 2019, it held more shares in EFS than was allotted to it under the share swap. And so the question therefore arises, well, how did Lane acquire them? That's a key question in this case. Now, Lane says that in May 2019, it subscribes for an additional 1,260 shares. That's Mr. Tabari's witness statement to paragraph 20, which is on page 725 of the hearing bundle. Now, in support of that, Mr. Tabari exhibits the share subscription form, which my learned friend took you to, and I want to take your honour back to that. It's in the hearing bundle at page 758.
Is this a point about the figures as to the exact amounts?
Your Honour, no. There are other points in relation to this explanation as to how the figures increased at this stage, which I want to take your Honour to first. So this is 758. This is the document which is relied upon as put forward by Lane as explaining how it increased the number of the shares it held. Now, the document is not dated. And if Your Honour goes to page, my bundle would be 759, but Your Honour's might be 760. I don't know whether I'm a page behind or not. But the second page of this form sets out in bold font some notes which are of import. So the notes essentially set out some conditions in relation to the subscription. It requires that there must be a resolution, an executed resolution of the subscribing shareholder within 7 days of submission of the form. Pausing there, no resolution has been provided. That's something that Lane clearly must have, but hasn't produced. The subscription request is said to be subject to proof of payment. No evidence of payment has been provided. The notes refer to, or rather not the notes, but underneath the notes, just after where it says in witness whereof, it refers to being duly executed and a stamp of the company being affixed on the above mentioned date. Well, there's no stamp, and as we've just seen, there's no date. And then below that, it says, on behalf of, brackets, please insert exact shareholder name. No name of the shareholder is inserted. But what we do have is a signature by Zaina Tabari as managing director of Lane. So whilst Your Honour has a subscription form, Your Honour does not have evidence, which Lane must have, which conclusively shows that it increased its shareholding in 2019 by a valid and effective subscription of the additional shares. Now, in addition to that, Lane says that in July 2019, it sold 1,912 shares in EFS to a Jordanian individual by the name of Akrima Afani. So that's in Mr. Tabari's witness statement at paragraph 21. Now, just pausing there, 1,912 shares, in terms of the number, is in excess of the 3% of the shares which Cayan says it should have received under the share swap, because it should have received 3% of 50,000, which would have been 1,500 shares. So there was a transfer out by Lane to Akrima Afani in July 2019. But in relation to that, there's only very limited evidence in support of this. Firstly, and Learned Friend took you to this, Lane relies upon an EFS board resolution approving a transfer from Lane to Akrima Afani. That's at page 761. Now, of course, whilst this shows approval of the transfer, it's not evidence of the transfer itself. What is relied upon as evidence for the transfer is the fact that, this is on page 763, Akrima Afani is recorded as holding 1,912 shares in the shareholder register. But beyond that, there's no board resolution from Lane as to the sale of the shares to Akrima Afani. There's no executed sale and purchase agreement. There's no evidence of payment by Akrima Afani for the shares. We don't even know who Akrima Afani is. I mean, other than the person who's Jordanian, as is, I understand, Mr. Khaldun Tabari. There's no share transfer instrument from Lane to Akrima Afani. And so again, there's no evidence that clearly establishes that Lane did validly transfer and sell shares to Akrima Afani. Then on a comparison between the two shareholder registers from 25th of April and 24th of September, it does appear that some share transfers have been taking place. So according to the 25th of April shareholder register, EFS Facilities, this is on page 751. This is the document.
Need to go a little bit slower at this point.
Very, very good, Your Honour. So the first shareholder register.
This is the April one.
Yes, this is the April one. So according to this shareholder register, on the top of the second page, a company called EFS Facilities Limited.
Yes.
Which is another company connected to the Tabari family.
Yes.
It held 9,750 shares. That's 19.5%. Then on the following page, we see Walnut and Bank Canada with their 11.75 and 11.5% respectively.
Yeah.
And those shareholdings will between total 21,375 shares, which is 42.75%. Now, the 2nd of September register, which is on page 763, does not record EFS facilities, Walnut or Bank Canada, as being shareholders. But as my learned friend pointed out, there is a new shareholder, not previously recorded in April, being the Kuwaiti company, Al Adnan Real Estate Company, which is on page 765. And that company holds, or was recorded as holding, 43.11% of the shares. So that's more than all of the shares of Walnut and Bank Canada and EFS facilities put together. So it's received a percentage from somewhere else as well. But what we don't have is any evidence which explains how those differences in the two shareholder registers came about. My learned friend postulates that, well, the shares from Walnut and Bank Canada went to Al Adnan, but there's no evidence of that. And in fairness to him, I think he put it no higher than that's what looks like might have happened. But there's no evidence to conclusively prove that. But what this shows is that there were movements in the shareholdings of EFS, including transfers from companies connected with the Tabari family, of very large proportions of the shares in EFS, which are completely unexplained. Now, the evidence in support of these applications has been provided principally by Tariq Tabari, who is the son of Khaldoon Tabari. Mr. Tariq Tabari was a director of Lane. He was a director of Walnut and Bank Canada, and he's a director of EFS facilities. So he ought to be in a position to explain how the alterations in the makeup of the shareholders has come about, particularly in relation to the companies with which he and his family are connected. And for all Cayan knows, and what the shareholder registers do not confirm either way, is that the shareholdings from Walnut and Bank Canada went direct to Al Adnan. They could have gone from Walnut and Bank Canada, as we have been told, to Lane and then onwards to Al Adnan. It's simply not clear. And one has to bear in mind, Your Honour, that at the time of these shareholder fluctuations, Mr. Khaldoon Tabari had left the UAE. He and his daughter Zaina Tabari were the subject of criminal proceedings in Jordan for fraud. We see that in the reference on page 543 of the hearing bundle, which is the release from Drake and Skull, of which Mr. Khaldoon Tabari was previously CEO, which refers to criminal proceedings in Jordan for on charges of fraud, which were finally instituted in 2019. You can see the reference on page 543, the fourth line down. There was a criminal case number in 2019. Drake and Skull have carried out an internal investigation into a fraud carried out by Khaldoon Tabari and filed a criminal complaint. We also know that Drake and Skull had issued proceedings in Dubai for claiming 470.5 million dirhams. That's referred to on page 579. In a judgment of the Dubai Court of Appeal.
Well, that's all very good, but how does it help?
Well, Your Honour, what it shows, it gives you context that there are substantial transfers of shares between Tabari companies, Tabari related companies, and at the same time there has been unlawful conduct by Khaldoon Tabari and Zaina Tabari about the same time. And my submission to Your Honour is that Your Honour should therefore treat the evidence that's provided by the Tabari family in relation to these matters with extreme caution, and certainly not as gospel. Now, against the evidence relied upon by Lane, Cayan's case is that it was told by Mr. Gubar, EFS's general counsel, and Mr. Chowan, its CEO, that the shares from Walnut had been gifted by Walnut and Ban Canada to Lane. And Your Honour would have seen that it's paragraph 11 of Mr. Al-Hatti's witness statement in support of the stop notice. That's at page 41. And again at paragraph 50 on page 432. And it's expressly pleaded at paragraph 47 of the amended particulars of claim. That's on page 263.
Yeah.
Now, while I accept, as I must, that it will be Cayan's burden at trial to prove its case, on this application, Lane bears the burden of showing the negative proposition that Cayan has no real prospect of success. Now, for the reasons I've already submitted, Lane's evidence does not show that what Cayan was told, that's to say that the shares were gifted to Lane, is factually incorrect. Specifically, Lane has not provided any evidence from Mr. Chowan, for example, in the form of a witness statement, any evidence from Mr. Chowan or Mr. Gubar to contradict what Cayan says, despite the fact that Lane and EFS are co-defendants, despite the fact that Lane is a shareholder of EFS, and that Lane and EFS have a common director, Mr. Tariq Tabari. So this is not evidence that would be in any way impossible or even difficult for Lane to produce. But on the one hand, before Your Honour, on this application, you have a witness statement from Mr. Al-Hatti with a statement of truth saying that he was told that the shares had been gifted to Lane, and he was told by Mr. Chowan and Mr. Gubar. On the other hand, you do not have a witness statement from either Mr. Chowan or Mr. Gubar saying that that's not correct. And so, even on that basis alone, there is clearly a real and genuine issue as to whether or not Lane did receive the shares from Walnut and Ban Canada. And my learned friend labours the point. I understand why, but he labours the point that it's a hearsay statement. And he can make that criticism at trial with the benefit of cross-examination and disclosure. But on an application like this, at its very highest, that criticism simply highlights that there is a genuine issue as to whether or not Lane was gifted the shares. The criticism that my learned friend makes is that the evidence relied upon by Cayan is inadequate and limited to that hearsay statement. And as to that, there are some obvious points to be made. Firstly, Cayan does not have any, let alone extensive access to the information and documents relating to the EFS corporate transactions or transactions involving its shares. Similarly, it has no access or detailed information concerning Lane, which is a BVI company, and as such is not the easiest to obtain information about. And so it's unrealistic and I would submit unfair to expect Cayan to present a suite of evidence that clearly shows that the shares were transferred to Lane. That, for my learned friend to require Cayan to do that is not only unfair, but it's not the test. Cayan does not have to prove its case on this application on the balance of probabilities. It merely needs to show that it has that there is a basis on which it advances its case, and it advances its case on evidence which is not directly challenged by Lane. The criticism made is also particularly unfair because Lane, and in particular Mr. Tariq Tabari, does have access to all of the relevant information, but has not provided it to clearly prove that Lane never received the shares. For example, well, before I move on to that, there's another element in the evidential makeup, which is this: that in a letter of the 29th of November 2024, in response to the stop notice, Lane's lawyers denied that Lane had received the shares, quotes, as a gift. What they did not say was that at that point was that Lane had never received the shares at all. Now, the reference for that, Your Honour, is hearing bundle page 1053. So this is a letter from Lane's lawyers, Allied Iris, in response to the stop notice. And on page 1054, this is under the heading Substantive Defects, paragraph 4 of the letter. Paragraph 4.2, what's said is this: at no point did our client receive shares in EFS Facilities Management Limited as a gift from Walnut International Limited or Bank Canada Limited. No statement there that there was no receipt at all, but simply that they weren't received as a gift. Now, the fact that Cayan does not have more evidence that Millennium Friend says should be provided, although, as I submit, that's an unfair requirement at this stage. The fact that Cayan does not have more evidence is not for want of trying. On the 9th of December 2024, Cayan's lawyers, Hadef, invited Lane to provide Cayan with contemporaneous evidence to show that it was a bona fide purchaser of shares. Now, this was in response to the letter we've just seen, which said that the shares had not been gifted. And so we see the request on page 1058. At paragraph 11b of Hadef's letter. So that's where Hadef asked for information to show that Lane was a bona fide purchaser of the shares. Now that request was not responded to. Instead, what we got were the applications which are before Your Honour today. Then on the 28th of January 2025, Hadef wrote to EFS requesting a full account of EFS's shareholding through a complete record of its shareholder register. And as I submitted to you previously, Your Honour, that's a record that EFS is required to maintain. That request is referred to in Fazal 3 at paragraph 26. And I think the letter we've already seen already today is at page 334. And in paragraph 7 of that letter, on page 335 and over to the page 336, Hadef asked for information which would, if I can summarize, clear up this issue as to whether or not the shares were transferred to Lane.
So which
Now that-
paragraph?
Paragraph, well, in particular, paragraph 7G.
Oh, yeah. Let me just read 6 and 7.
Thank you.
Yeah. Yeah.
We also requested information from Altamimi, being the law firm of which Mr. Khan, I think, was now formally a partner. Mr. Khan being the nominee. There's a request which was sent to Altamimi at page 1083. This is dated the 18th of February 2025.
So is this after proceedings have commenced?
Yes, because you're on a just the sequence is that
Yes.
Cayan is informed that the shares have gone to Lane. The proceedings have commenced. The defence then comes in saying, well, Lane never received them. We want information to explain which version of events is correct. And so we've gone to EFS and no response. We went to Mr. Khan and we asked for documents at paragraphs 11 and 12 on page 1085. Under the heading final requests. So there had been previous requests for documents to establish the position. But we haven't had any response to that either. And then, as Your Honour saw earlier, on the 14th of April 2025, HADEF also wrote to Lane requesting information regarding the share transactions maintained at the EFS registry, and that's at page 1091. And it was in particular paragraph 7 and 7A specifically, which is on top of page 1092.
So this is in identical terms.
Yes.
Yeah.
Yes. And
yeah,
the response we got to that, Your Honour will see on page 1137. It's a letter from Allied Aras dated the 30th of April 2025. And paragraph 4 responds to HADEF's paragraph 7.
Yeah.
And what the denial of receipt of the shares is repeated, this time by gift or otherwise. And what's said is that if the claimant wishes to have a comprehensive and detailed record of all share transactions maintained in the EFS's registry since inception, the claimant should request the documents from the first defendant, who owns the documents, rather than the second defendant, who is one of the many shareholders. Now, at first blush, one might say, well, fair enough. But one has to bear in mind that Mr. Tariq Tabari, Lane's director and witness, is a director of EFS. Lane is a shareholder of EFS. So if Lane is going to pursue these applications to say that Cayan has no real prospect whatsoever of establishing receipt, it bears the burden of establishing that on these applications overall. Lane must have, through Mr. Tariq Tabari, access to this information. But instead of being helpful and responding to a very pertinent question, the response is simply, well, you're not going to get it from us. You have to go to EFS. And we've already tried that, as Your Honour has seen, and without success, unfortunately. So, as I submit, it's not for want of trying that, in light of the defence which has been filed on behalf of Lane, that Cayan has then sought to obtain the information which we say will inevitably have to be disclosed at some point in these proceedings. We're faced with a refusal to cooperate. But where that leaves us, in my submission, is that it simply cannot be said by Lane on these applications that there is no real prospect of success. And I simply refer to the submissions I made earlier, that we've been told that these shares were gifted to Lane, and there's no evidence before the court which shows that there is no real prospect of that allegation failing at trial. This is clearly an issue which should proceed to trial. It's a claim which should proceed to trial. Once we get to the stage of disclosure of witness statements, the court will have the benefit of that further evidence, which must be there. And in those circumstances, this is not a claim that the court could or should dismiss on a summary basis, bearing in mind the direct conflict of evidence on the application and the strong likelihood that there will be further documentation to come to light, which will demonstrate what transactions took place in relation to these shares from April 2019 and onwards. So, Your Honour, this is not McCorberism. This is not a situation where the claimant is saying, well, something will turn up. There is a shareholder register. There will be documents which underlyingly support or contradict what's on the shareholder register. And that evidence will be obviously relevant to the question upon which Lane currently focuses, which is whether or not it received the shares from Walnut and Bank Canada. But in any event, there is a flaw in my submission with Lane's submission in this regard, because it appears to be saying that when one looks at the figures comparing the two shareholder registers, it's mathematically impossible for Lane to have received the shares from Walnut and Bank Canada, and that whatever it's holding does not amount to shares which it did receive from Walnut and Bank Canada, i.e. they're Lane shares. So the argument is that the shares from Walnut and Bank, or held by Walnut and Bank Canada, are separately and specifically identifiable. Now, that is wrong as an overall submission for a number of reasons. Firstly, the shares in EFS are not specifically designated, and so if they were transferred to Lane, as we've been told they were, they could not be separately identified from other shares that it held. There would be a mixed group of the shares held by Lane, because they're not specifically identifiable.
Well, you're then into the business of if they are trustees of trust property as compared with other property.
Yes, exactly. So you're on to seize the point immediately, because if the Walnut and Bank Canada shares are mixed with Lane shares, the fact that Lane then transfers out shares from the mixed group of shares does not defeat the proprietary claim, because if if there has been a mixture of the shares, which we say there has been, then the rules on tracing presume that all of those shares are held on trust for Cayan, and that the shares that are transferred out are Lane's shares, so that what Lane is left with holding are shares over which Cayan can assert a proprietary claim.
Yeah.
Now, in light of the Millennium Friends skeleton, because this wasn't trailed either in correspondence or in support of the application, it became clear what point was being made, which was that the shares are all specifically identifiable and traceable, which, as I've submitted, isn't right. They were mixed. I've given Your Honour the principles on which I'm sure Your Honour already has, but just for the record, the description of the principles on the tracing rules in lieu on trusts and in civil fraud. In Lewin there in the hearing bundle at page 2181. And it's paragraph 44095.
Yeah, well, this is trade law as far as I'm concerned.
I anticipated that I was perhaps overdoing it by referring to this, but it's a point that it emerges from a learned friend skeleton, and so. So I think
to save some time, I've never suggested that the shares were mixed. My submission in the skeleton is that they were never received, that the shareholding is independent of any of the shares Walnut and Ban Canada ever had.
Yeah, you're not taking an issue, Mr. Hussain, with this principle.
Yes, but it's not even doesn't arise. I've never made an argument that the shares were mixed.
No, I understand what you're saying. Yes,
I'm grateful to my own friend, but Your Honour sees the point that there is an issue between us as to how the number of shares held by Lane came about. So the fact that Mr. Tabari refers to 1,912 shares being transferred to Krima Afani is no answer to the proprietary claim, because whatever is left in the hands of Lane amounts to shares into which Cayan can trace.
Yeah.
So the key point, therefore, is all about how Lane acquired 21.18% of the shares in the first place. As to which Your Honour has my submissions. There is, to say the least, some murkiness. Dealing with, therefore, the application overall, Cayan's claim isn't strikeable because it discloses an arguable claim, and on the key question as to whether or not Lane received the shares, there is an obvious and real, genuine issue as to which Cayan has a real prospect of success. Now, it's convenient, Your Honour, I would submit at this stage to then interpose the stop notice application, because if, as I invite Your Honour to do, Your Honour finds that there is a good arguable case or a real issue or a real prospect of success with regards to the receipt of the shares, and which is the only ground on which the application to discharge the stop notice is put, it therefore must follow that the stop notice should remain in place. And it's important to bear in mind what the stop notice does. It prevents EFS from registering a transfer of the shares or from making distribution by way of dividend in relation to the shares without providing 14 days notice.
Yeah.
And as Your Honour has already observed, nowhere in the evidence in support of the application to discharge the stop notice is it said by Lane that it wishes to or intends to transfer those shares at all, let alone in the near future. So if Your Honour is with me on the real prospect of success on the summary judgment on the immediate judgment application, then it would follow from that the stop notice should remain in place. That brings me to the unlawful means conspiracy claim. Now, we've already looked at this today with my learned friend's assistance. It starts in the amended particulars of claim at paragraph 111, which is page 284.
Yeah.
And I appreciate Your Honour's already looked at this, but I just want to sort of take through it in stages to just develop my submission. So paragraph 111 refers to and repeats previous paragraphs, specifically 15 to 20, 39, 58 to 62. So 15 to 20 sets out the SPAs and how they came about and were entered into. 39 is the pleading that Walnut and Bank Canada did not acquire good title, and so were not entitled to the 3% shares in the share swap. Paragraph 58 is the claim for dishonest assistance, and paragraph 60 is the claim for knowing receipt. Now, in addition, the very close connections between the Tabari family, Lane, Walnut and Bank Canada, and EFS are pleaded above. Your Lordship, Your Honour will have seen them, but just to recap, paragraph 4 sets out the links between the Lane and the Tabaris. Paragraphs 5 and 6 sets out the links between EFS and the Tabaris. Paragraph 6 sets out the links between Walnut and Bank Canada and the Tabaris. Paragraph 16 sets out the links between EFS, Lane, and the Tabaris. And paragraph 20 it sets out the connection between the Tabaris, Lane, and Walnut and Bank Canada. So we have the close connections between the Tabaris and the various companies set out in those paragraphs. Then in the next paragraphs, the elements of the cause of action are set out. So in paragraph 112, there's the pleading of the combination. And that's a pleading of, it's an inferential case, which is, in my submission, unusual. It's not unusual for conspiracy claims to be pleaded by way of inference, because of course we are the victim of the conspiracy. We don't know fully all the facts. It's in the nature of a cause of action that it would be inferential, looking at the acts of those alleged to participate. So we infer from all these close connections and what happens to the SPAs and the share swap, that EFS and Lane and Tabaris entered into a combination whereby they knew that Walnut and Bank Canada or Lane were not entitled to the shares in EFS, and they procured, knew of, and approved and included in the transfer of the shares. So that's the allegation of the inference. And as I say, it's an inference which we say can be drawn, and this is dealing with my learned friend's Three Rivers point. We say that's an inference that can be drawn on the basis of the pleaded close links the pleading of Lane using Walnut and Bank Canada as SPVs to acquire the shares, the pleading of the control of Walnut and Bank Canada by Lane and the Tabari family, the non-payment under the SPAs, the pleading of the instruction, or the pleaded fact of the instruction to Mr. Khan to transfer the shares to Walnut and Bank Canada, and indeed what we plead, which is the transfer of the shares from Walnut and Bank Canada to Lane. So we say that assuming those facts are correct, which for the purposes of strikeout, Your Honour should do, assuming those facts to be correct, those set out facts from which the combination can be inferred. Paragraph 113 sets out the intention to cause harm. And we say in relation to this, well, it's obvious that if there's a combination to deprive Cayan of its shares under the share swap, at the very least, it's to be inferred that there was an intention to cause that financial harm to Cayan. And then the unlawful means are pleaded at paragraph 114. So 114.1 is procuring the breach of Mr. Khan's duties. 114.2 is the receipt. 114.3 is it relates to different causes of action and therefore different forms of unlawful means, but it essentially comes to the same as 114.1, which is procuring the breach of duty by Mr. Khan, and the same can be said for 114.4. So that's the pleaded case. So far as the application to strikeout is concerned, the grounds I've referred to learned friend's skeleton argument as making different points, but I think it's important just to sort of chart how we've got to this position. The points that were made in Mr. Tabari's witness statement were specifically made at paragraphs 24 to 30, and that's at pages 727 to 729. Or it might be in Your Honour's bundle 726. So it's section D3 of Mr. Tabari's witness statement dealing with no conspiracy. And Mr. Tabari essentially here makes 3 points. Firstly, he says that there cannot be a conspiracy alleged because Lane did not receive the shares. That's paragraph 24. Secondly, he says that Cayan entered into the SPA with not Lane, but Walnut and Bank Canada, which are separate from Lane, and therefore this is really just a matter between Cayan and Walnut and Bank Canada. That's the gist of paragraphs 25 to 28. And then thirdly, Mr. Tabari makes the point that the affairs of Lane are managed by its directors. That's a paragraph 30. Now, just dealing with these points in turn, the non-receipt, Your Honour has my submissions on that. That's we say, so far as strikeout is concerned, it's pleaded. Insofar as it's said there's no real prospect of success, well, for the reasons I've submitted, we say that point is bad. The second point, that Lane did not enter into the SPA with Cayan, well, that with respect is not an answer to the conspiracy claim. The fact that Lane didn't enter into the SPA directly with Cayan doesn't exclude a conspiracy involving Lane if the combination was to procure the transfer of the shares as initial step to Walnut and Bank Canada. So that it's not an answer to the alleged combination, and the combination as pleaded at paragraph 112 is not attacked on this application. And what I mean by attacked, what I should more properly say is that there's no evidence relied upon for the purposes of summary judgment to say that there's no real prospect of success in relation to that combination. And there's no challenge to it for the purposes of strikeout. But even putting that aside, the suggestion that that there can't be a conspiracy because Lane didn't enter into the SPA completely ignores the close connections between Lane and Walnut and Bank Canada and EFS, none of which are challenged by Lane on this application. And this is where it's something of a sideshow, but this is where paragraph 30 of Ms. Fazal's third witness statement comes in. Just for your honour's note, it's at page 1017. But this is where this paragraph comes in because Ms. Fazal at paragraph 30 sets out, I think, 13 points in all, which demonstrate the close connections between the Tabari family, Lane, Walnut and Bank Canada and EFS. And the reason why that is in is because it was suggested, it's suggested by Mr. Tabari in his witness statement that there's no connection between the entities. We say that's hopeless in any event, but at the very least there's a real prospect of success in establishing that. So that's the reason why Ms. Fazal goes into some detail in paragraph 30, setting out all of those various points. But the short point is that the second argument raised by Mr. Tabari is clearly a bad one because it doesn't answer the conspiracy claim as alleged, and it ignores the close connections between the various entities. And then the third point made by Mr. Tabari, which is that the affairs of Lane are managed by its directors. I confess, and again with respect, it's not clear what point is being made here.
Well, it's the absence of link point again, isn't it?
I'm sorry, Your Honour.
I think the point being made is the absence of any link between the point you've just addressed.
Well,
saying it's an
yes.
independent, it does its own thing regardless of anybody else.
Yes. Well, we assume that Lane operates by its directors, and no suggestion is made in the pleading otherwise. A point I'm going to come on to in a moment. But the fact that Lane operates by its directors does not exclude it from being a party in a conspiracy.
Sure.
So beyond that, the points that are made in support of the application in Mr. Tabari's witness statement are really a bare denial of the conspiracy claim, without any documentary evidence to challenge the allegation or to show why Lane was not involved in the conspiracy. Now, that then brings me to my own friend's arguments in his skeleton. And there are two main points he makes. Firstly, that there are insufficient particulars given of the unlawful means, and specifically that there are no particulars of an allegation that Lane procured, was aware of, or facilitated Mr. Khan's breach of duties. And the complaint is made that the only unlawful act pleaded as committed by Lane was the knowing receipt of the shares. So that's Malone and Friends, paragraph 54 in his skeleton. And then the second point that's made is that there's no pleaded basis for attributing the actions of Lane's directors or those in control of Lane to Lane itself. And as he helpfully expanded on his skeleton earlier, his point is that there's no agency or authority is pleaded. That's paragraphs 57 to 58 of his skeleton. And he says, as a matter of law, there's no presumption that the acts of a director are attributable to a company. And that's his paragraph 59. Now, before addressing those, it's important just to bear in mind what Lane does not challenge for the purposes of the strikeout. There's no challenge to the combination, as I've submitted. There's no challenge to the intent to cause harm. And there's no challenge to the unlawful means used pursuant to the conspiracy, save for the factual issue on receipt, which we've dealt with. So taking the 2 points, the first point, insufficient particulars of unlawful conduct by Lane. In essence, this is an argument that each conspirator must have carried out each unlawful act at each stage of the conspiracy as if it were a joint tortfeasor. My own friend's submission is, well, the only wrong that's said to be committed by Lane is the knowing receipt, and that the procuring of the breach of duty by Mr. Khan it isn't set out and not specifically alleged against Lane. But with the greatest respect, that as a matter of law, that's incorrect for the following reasons. The liability for unlawful conspiracy is for entering into the combination in the first place, pursuant to which unlawful means are then used. So the primary liability is agreeing to harm someone by way of a conspiracy. And it's well established that it's not necessary for each of the conspirators to be involved either at the same time or indeed to carry out each and every unlawful act. Indeed, it may be that a conspirator does not carry out any unlawful act, but is still liable if they agreed that the unlawful acts were to be used by other parties to the conspiracy. Now, I anticipate Your Honour may say, well, this is all trite law, but for good measure, I've given Your Honour some authority on this. We have an excerpt from Civil Fraud, which is at page 2354. And it's paragraph 2119 from the textbook, and in particular, subparagraph 1.
Yeah.
And then just to give some case law colour to that, I've referred, Your Honour, to the Kuwait oil tanker and Al Badair case. And the relevant section in that is at page 2227. And if Your Honour were to read paragraphs 132, which starts at the bottom of 2227, and paragraph 133.
Yeah.
Now, of course, in this case, it's pleaded at APOC paragraph 112 that EFS, Lane, and the Tabaris entered into a combination whereby they procured, knew of, and proved and colluded in the transfer of shares to Warnock and Bank Canada and onto Lane instead of Cayan. So that's what's pleaded. And as I've already submitted, that pleading is not challenged at all. So assuming that to be true, Lane is therefore liable in respect of any of the unlawful acts which are carried out pursuant to that combination. And its liability is accrued, even if it did not directly carry out any of the unlawful acts which were anticipated by the combination. So, Malone and Friends objection to the pleading that it does not set out how Lane procured the breach of Mr. Cayan's duty is a bad one, because as long as Lane was party to a conspiracy by which it was intended that, for example, EFS was going to instruct Mr. Cayan to transfer the shares to Warnerton Bank Canada, then Lane is liable. I beg your pardon. Lane is liable for the unlawful act of procuring Mr. Cayan's breach of duty, because it was carried out pursuant to the conspiracy. So that deals with that point. But and of course, we rely upon the knowing receipt claim in any event, which we say is unlawful. That then brings me to the second point, which is one of attribution. The first argument here is that there's no pleaded basis for agency or attribution. Now, just stepping back, Your Honour will have seen that in paragraph 4 of APOC, we set out who has been and who are the directors of Lane and those with control and who are the ultimate beneficial owners of Lane, namely the Tabari family and the various members of the Tabari family. So that's set out in paragraph 4, and again, there's no challenge to that on this application. Now, as a company, Lane operates via two organs: its directors or its shareholders. And insofar as we plead that we identify who the directors of Lane are and who are its controllers, there is no need, in my submission, to plead the director is authorised by the company, because that authority is inherent in the office of director. That as a proposition, that is tried. So this is a very different case to that relied upon by my learned friend in his skeleton argument, which is the Emirates MBD Bank and Advanced Facilities case. Because in that case, the argument was that was advanced was that Noor Bank had acted as the agent for other banks in negotiations for a proposed syndicated loan. And one can immediately see, therefore, that if you've got a separate company, a separate commercial entity, as a matter of law, there is no immediate agency in the same way that there is between a director and the company of which that person is a director. And it was held in the Emirates and Advanced Facilities case that there was just simply no evidence to support the allegation of agency. It was a factual question there. So that's very different, as I say, to the position in this case. And indeed, in the passage referred to by my learned friend in his skeleton, in the Emirates and Advanced Facilities case, it was noted in paragraph 35 that agency is a legal construct, not a fact, but a conclusion from the fact. So where, as in this case, you have the fact of a person acting as a director or of a person who is its controlling will and mind, where that is pleaded, in my submission, that is sufficient basis on which to assert agency or authority. That's the legal point. The practical answer to this is that the argument is in any event a straw man, because the allegation in the amended particulars of claim, which is pleaded at paragraph 112, is that Lane entered into the combination. There's no pleading that a person other than Lane entered into the combination on Lane's behalf. So we've already pleaded that Lane was party. So I with respect, this question of attribution is somewhat of a red herring. but then dealing with my own friend's other argument, which is that there's no presumption of a director's there's no presumption of attribution of a director's conduct to a company. My own friend here is making an interesting argument because to get round the problem, he submits that that there's not a good, it's not good enough to allege that Lane acted in a certain way, which is what we've done. We've alleged that Lane entered into the conspiracy. My own friend criticizes the pleading because he says, well, Lane is a company which acts via its directors, but at the same time, Lane argues that it's necessary to plead why a director's conduct is attributable to a company because it can't be presumed. And there's a circularity in that submission. I would submit, but just dealing with it, Your Honour, briefly. Malone Friend relies on Singularis and Daiwa, and that was a case. Your Honour may well be familiar with it, but that was a Quince care duty case. The issue was whether the defence of illegality could be relied upon by the defendant bank when it was being sued for breach of the Quince care duty. And the bank argued that the conduct of the fraudulent director who had instructed the bank to make certain transfers was attributable to the company, and so it couldn't rely on its own fraud. And the court rejected that on the basis that you can't attribute the fraudulent conduct of a director to the company in circumstances where that fraud, that breach of duty, was the very thing that the Quince care duty was there to prevent. So it would, by attributing the fraud of the director to the company, that would render the Quince care duty null and void. Essentially, it would just remove it, and it would be absurd, and therefore there was no attribution. The principle, though, which it relied upon in the Singularis and Daiwa case was the wider principle established in Bilter versus Nazir, which is that the question of attribution depends on the context and the purpose for which attribution was relevant. So one has to look at the circumstances and decide, well, is it appropriate in these circumstances to attribute the knowledge and conduct of a director to the company? And where you've got a company suing its where you've got a company that's the victim of a fraud suing a third party for breach of a duty, it would be absurd to attribute the fraud of the dishonest director to the company. The reliance on the Bilter point in Singularis, we've got it in the bundle. It's at page 1976, I believe. No, it's page 1977. And if Your Honour were to read paragraph 30,
Yeah.
Now, I do need to take you briefly to Bilter, because that's where the wider principle comes from. And we can go to two parts of the judgment. Firstly, the judgment of Lord Sumption. That's at page 2286. And could I please ask Your Honour to read paragraphs 87 to 89?
Yeah.
And then, well, just pausing there. So that draws the clear distinction between situations where a third party sues a company for a wrong, such as a fraud, and in those circumstances, because it is if I can put it this way, an external claim from an outsider third party, in those circumstances, the conduct of the directors is attributed to the company, the defendant company, by virtue of their office and simple laws of agency. But where a company is suing its directors for breach of duty, and in particular fraud, then of course it would be absurd and circular to suggest that the wrongful conduct of the directors is to be attributed to the company. Now, and there's a third instance in relation to how this all works is given at paragraph 91 of Lord Sumption's judgment. Then, just very last point on this, Your Honour, at page 2319, if Your Honour were to read paragraphs 204 and 205, this is where Lords Torson and Hodge also make the same distinction.
Yes.
Now, in this case, Cayan alleges that Khaldoon Tabari and his family were and are directors of Lane and have ultimate beneficial ownership and control of Lane. Cayan is a third party which claims against Lane, and so this is not a case of Lane suing its director or agent for breach of duty. It's the first type of case, and so whatever the directors do on behalf of Lane, and we say that its directors and controllers caused it to enter into this conspiracy, that knowledge and conduct under basic agency principles is attributable to Lane. And for good measure, I should add that on this application, Lane does not seek to strike out the allegation that the Tabaris were directors of or in control of Lane, nor does it rely upon any extraneous evidence outside of the pleadings to deny that. And then the last point to be made to make on this is that the question of attribution, this novel argument on attribution my friend has introduced, is in any event academic, because a person who is a director of a company or controls a company can conspire with the company which they direct and control. That is trite, I would submit again, and is a principle which is expressly acknowledged in Clark and Lindsell at page, in the hearing bundle at page 2330. This is the relevant excerpt from Clark and Lindsell on unlawful means conspiracy, and at page 2330, third line down, about 2/3 of over to the right hand side, there's a sentence beginning "a company." If Your Honour could read from there to the end of that paragraph, then that should suffice.
Yeah, yes, there's a distinction between a one-man company, isn't it?
Yes. So all of these points on attribution, which I've taken up, I do apologise, some time in my submissions, actually come to naught, because putting aside attribution, the directors or those controlling Lane can conspire with their company in any event, and we allege that the Tabaris did just that. And that's a pleading which is not challenged. So, for all those reasons, Your Honour, we say that the criticisms of the APOC, the amended particulars of claim, with regards to the unlawful means conspiracy, are based on arguments that are bad in law. And they do not properly reflect what is pleaded. No other criticisms of the pleading are made, and no evidence is relied on to show there's no real prospect of success other than the receipt point. And so, for those reasons, the strikeout application with regard to unlawful means conspiracy should also fail. There is one final point, because as this is being advanced as an immediate judgment application as well, there is the second element under 24.1 subparagraph 2 that my learned friend has to establish, which is that there is no other compelling reason why the case or issue should be disposed of at a trial. And my submission is that there are compelling reasons why this matter should proceed to trial. The claim is highly fact sensitive. It's a claim alleging dishonesty, which is largely based on inferences which are highly fact dependent. And this is just the type of claim that the court has said ordinarily should not be the subject of summary disposal, but requires to be determined at trial. My learned friend makes various points about the various share transactions, but on any view in my submission, it cannot be said that those are transactions or those are changes in the makeup of the shareholders, which even if at first blush they look legitimate, that they are not matters which require further investigation. And that is just the sort of reason that was highlighted in the easy air principles governing the grant of immediate judgment, which was identified. So at a very base level, all of these transactions require to be investigated. It can't be said that that they clearly should be viewed without any further explanation. They're also the subject of the other claims in relation to which the other defendants have not applied for immediate judgment. And so these matters are proceeding to trial. There will be disclosure, there will be witness statements dealing with what's happened to these shares. It may well be in any event that Lane is going to have to provide some disclosure in relation to that, even if it's not directly involved in some of the transactions which are the subject of these proceedings. But for those reasons, not only do we say that there is a real prospect of success, but of course, in a case like this, it is obvious that the matter needs to go to trial. It's a claim in relation to fraud, which clearly calls for investigation, and it is telling that Lane and EFS and Mr. Khan have repeatedly refused to provide the information which I assume they would say would put this matter beyond any real doubt. So for those reasons, Your Honour, I'd invite Your Honour to dismiss both applications.
Yes, thank you very much. Mr. Hussain, shall we take a 5-minute break at this point and then you can reply?
Of course, Your Honour.
Very good. Say 15:15 or thereabouts. Thank you very much. Yes, Mr. Hussain.
Your Honour, I'm going to reply relatively briefly on the two main topics. Firstly, whether there's a real prospect of Cayan establishing receipt of the shares by Lane, and then secondly, whether an unlawful means conspiracy case can be maintained absent any real prospects of establishing receipt. So starting with receipt, if we can go back to what is the starting point and the incontrovertible point about Cayan's case, which Cayan is avoiding. If we go to page 263 in the bundle, we have the amended particulars of claim at paragraph 46.
Yes.
And we see the pleading in or about September 2019, Walnut and Ban Canada transferred to Lane the shares in EFS that had wrongly been transferred to them by Mr. Khan. The reason why September 2019 is pleaded is because that is the date that Walnut and Ban Canada, 10th of September 2019 is the date that Walnut and Ban Canada ceased to be shareholders in EFS. The only evidence identified, even as I speak now, to support this central allegation is at paragraph 47, that in early 21, the claimant was verbally informed by Mr. Guber and Mr. Chauhan that the shares had been gifted to Lane. That is the only evidence of underlying the case in receipt. It cannot be right that the DIFC will allow claims to proceed purely and solely on the basis of hearsay verbal statements, not least because in this case there is no record of the statement taken down at the time. There is no approach in 2021 to Lane or anyone else saying why are we being told that these shares have been given away. In 2024, when the lawyers write careful letters, including to Mr. Guber, they never mention this conversation. Mr. Guber has signed a statement of truth to EFS's defense, which denies this conversation. So the starting point is it simply is not a realistic prospect of success for a throwaway hearsay statement with no other record to found a case in knowing receipt. However, if the court was minded just to look at that, we then proceed. My learned friend started today by saying, said at the start of his submissions, and I'm not taking a perfect note, but he said something along the lines of DIFC companies have an obligation to maintain a continuous shareholding registry. There will be a daily register held by EFS. Well, firstly, this is not something that the court can take as a judicial fact. I mean, the common example of a judicial fact is something that the court can take judicial notice of is something like Christmas falls on December 25th. My client is a BVI company. We have no way, and we've not been shown anywhere in the regulations where a company like EFS would be obliged, as at September 2019 or before, to maintain a daily register of shares. That's the first point. Then there is no basis for suggesting that it in fact maintained such a daily register of shares. And then finally, there is no basis for asserting that if there was such a daily register, there is any likelihood that it would show a transfer to Lane. And then obvious point is my client is BVI company, doesn't have access to any alleged daily share register, doesn't even know if it exists. My client has produced the documents that it has. And it's also worth noting, my learned friend emphasized that there had been requests for information. There has never been a request from Cayan saying, we know there's a daily register, can you give it to us for the following dates? The request, if we go to page 1090, which is a letter of the 14th of April 2025, I'll wait for you to get there, Your Honour, is at the following page, at the bottom of page 1091, at item 7. It asks for a comprehensive and detailed record of all share transactions maintained in EFS's registry since inception. This is not something that my client has, and this is not the same as saying, well, which is now you're being asked to assume as judicial notice of that somehow there must exist a daily register that EFS has, let alone that would show a transfer to my client. That's simply not a basis for maintaining this claim founded on this verbal hearsay statement. Then, when my client has patiently provided evidence of his shareholding, what we saw, and I don't mean this as a criticism, it's just talking about the substance of the submissions, was nitpicking about documents. It almost came close to suggesting that the documents were somehow not assumed to be genuine or real. And the two documents that were attacked are at, the first one is the share subscription form at 758. Let you get there, Your Honor. You have it, Your Honor?
Yes, thank you.
That sets out the number of shares. It is signed by Ms. Tabari. And in fact, if we go to the previous document, the shareholders resolution, which is at page 753, do you have it, Your Honor?
Yes.
It talks about, on the 14th of May 2019, a shareholders resolution to for a capital increase and asking for share subscriptions, interest and share subscriptions. If we go to the next page, it asks at item 9 for subscription forms to be sent. This was the documents we put in. It was never suggested to us till now that, well, these might not be genuine, or other kind of document is needed to satisfy what's really being done is that, having relied on this hearsay statement, now there's just an attack on everything we produce. And that is not the test. The test is whether there is a realistic prospect of success of the factual basis on which the allegation is made. And we say there isn't. The other point that was attacked was the sale to Akrim Al Thani, and we see that at 761. We see the board resolution approving the sale of shares. Now, what's being said is, well, this is somehow not good enough. We don't know if the money was paid, etc., etc. But firstly, this was never asked of before. But then, what will they then ask for? Will they ask for our bank statements, etc., etc.? The springboard for the allegation and the monies went to Lane still remains a alleged hearsay statement 2021. And in my submission, this more than counters the real prospect success of that hearsay submission. Otherwise, what the DRC would be doing is it would be allowing for a claimant to use the trial process, the claims process, as an investigatory process, and disclosure as a way of deciding who to pursue, rather than having a realistic claim, a well-founded claim, or at least a realistically founded claim, before it issues it. So in my submission, there is no real prospect of success for the knowing receipt claim, because the only evidence for it remains the this hearsay statement, verbal hearsay statement, of which there's no record, which is denied by the maker, and which is clearly contradicted by the documents Lane has produced. The only point that Cayan makes is, well, there may be something else out there. This is precisely a speculative argument. There is no basis for proper, realistic basis for Cayan to argue that a document exists that shows a transfer to Lane. And the idea that my client, a BVI company, could have done more in terms of providing an alleged daily share register of another company simply because they have a common director is simply not correct. Your Honor, on the large amount of time spent on whether the unlawful means conspiracy claim can be maintained, even if there was no receipt, I'm still, and this might be because we are somewhat at cross purposes, there cannot be a realistic prospect of an unlawful means conspiracy claim in the absence of the knowing receipt. Because if we go to the claim as pleaded, which is at bottom of page 284, we look at paragraph 111. Cayan refers to repeats the matter stated above in paragraphs 15 to 20, 39, and 58 to 62. And then it says, it is to be inferred that EFS and Lane and or the Tabaris. Who is the Tabaris? Is it Mr. Khaldoon and Zaina Tabari, who are not defendants to this claim? Including Tariq Tabari, entered into an agreement or combination in which, and then the agreement is pleaded, 112.1, they knew that none of Walnut, Ban Canada or Lane was entitled to receive the shares in EFS, to which Cayan was entitled pursuant to the share swap. So again, it starts with saying there was a combination where they knew that Lane was not entitled to receive the shares. So we take that out if they can't prove that realistically. So then what is the basis for the combination alleged against Lane? At 112.2, it is receiving the shares. At 112.1, my learned friend explained that, well, the combination is a fact that there were common directors. But having common directors is not a factual basis to assume a company was part of a conspiracy. It's certainly not more consistent with dishonesty than honesty. And if we go to a passage in the particulars of claim that my learned friend took you to, is paragraph 4. I'm just scrolling up to it. Paragraph 4 to 6. We don't have a date for the conspiracy, but the Cayan itself has pleaded that Khaldoon and Zaina Tabari were also directors of EFS. Mr. Tariq Tabari at various times was a director of Walnut and Ban Canada. So when he says that there were actions taken by the directors, in what role did they carry out these actions? This is why attribution is so important, because these weren't people whose only connection with this alleged connection with these, only connection with these alleged facts was as directors of Lane. They were directors of EFS and Walnut and Ban Canada. So where is a pleaded case that there was an action taken by them as agents of Lane, or in their role as with the authority of Lane in entering into a conspiracy? There isn't any. And we're simply expanding this hearsay statement many years after the alleged fact to keep cast a net. I mean, if there's a claim against Lane, why not a claim against any other company that Mr. Tabari is a director of? That cannot be a basis for the DIFC allowing costly claims to proceed to trial. I'm not sure there was a difference between us in terms of, I hope I was fair when I was taking you to the cases on attribution, that they do deal with a very different factual situation. Can a company be held, an innocent company be held liable for wrongful acts by its directors, the Queen Square Trust? I'm not suggesting that that is otherwise. But the fact is that simply saying, well, even if there wasn't a receipt, Lane can still face a realistic claim in conspiracy simply because of the identity of some of its directors, that simply is not enough for a claim, in my submission. The only other point, Your Honour, I said I'll be brief, is whether there's an other compelling reason to proceed to trial. I'm still do not understand what that other compelling reason is meant to be. One is said to be there may be further disclosure. That's assuming you find there is a real prospect of the receipt claim succeeding. But the only time we'd be looking at another reason is if you find there is no real prospect of the receipt claim succeeding. And the other point taken as well, there's a claim going on against other parties, and therefore this BVI company should also continue to face a claim. That's not a reason to proceed to trial. And the problem is that Cayan is seeking to use the trial and the continuation to trial as a way to decide whether or not it has a claim. But what it has to show you today is that it has a real prospect of succeeding in its claim, and it's not been able to do that. Unless I can assist you further.
No, thank you very much, Mr. Hussain.
Your Honour, can I briefly just come back on 2 points which were new points, and they'll be very brief, made by my learned friend. Just on this point of judicial notice as to the obligation to maintain a shareholder register, the legal basis for that is Article 44(1) of the DIFC Companies Law Act.
Yeah.
And the other point my learned friend made, which is this, that he postulated that, well, there's no reason just to focus on Lane as being involved in the conspiracy. Why not any other company that Mr. Tabari was involved with? Well, of course, that ignores the obvious point, which is that in November 2017, it was Lane which was acquiring shares in MCOR, and it ignores the point which we make very clearly in the pleading and in our evidence in opposition to these applications, that the draft SPA that Mr. Gubar first circulated referred to Vision being the previous name of Lane. So there are good reasons, which we have made very clear throughout, to link the share swap with Lane in relation to the shares that Cayan previously held in MCOR. So those are the only 2 new points I wanted to just come back to you on, Your Honour.
Yes. Do you want to say anything further, Mr. Hussain, in relation to those points?
Yes. So starting with the latter ones, the latter points, firstly, are that somehow, because an email had the word Vision in it, that was a suggestion that the shares should be sold to Lane rather than Walnut and Ban Canada. That is not, even if that is taken at face value, which was disputed, that's in 2017, that is not any basis for a factual finding that the shares were transferred to Lane in September 2019. And this is almost my learned friend trying to rewrite his case, because the only basis he's put for the transfer, pleaded carefully, is this hearsay statement. There's no getting around that. On the factual, on the legal point, I'm still struggling to find where it's suggested that there will be a daily register produced and available setting out each transfer of shares.
Well, I'm sorry to interrupt. I didn't say daily. I said continuous.
Nobody is suggesting daily. It's just there has to be a register of all dealings in shares kept by the company. That's fundamental as a matter of DIFC law, as it is in English law.
Right, but there's no suggestion, there's no basis for the suggestion, Your Honour, that the 2 registers produced by my client are a partial account, and that other registers, so there might be a partial account, but are an incomplete collection of registers produced in that period. There's no basis for the court assuming that.
Right, well, I have your point.
Thank you.
Right, thank you very much. Well, I shall give my reasons in due course, which I shall probably draft this afternoon. But the applications to strike out, the application for summary judgment and the application for discharge of the stop notice all fail in my judgment. So far as the application to strike out is concerned, I consider that the claims against Lane are sustainable as a matter of law on the facts that have been pleaded, and will turn in the end on issues of fact which require investigation at trial. There are plainly issues which require resolution in relation to whether or not Lane did receive the shares in question, and on that basis dishonest assistance, knowing receipt and unjust enrichment are all potential claims to be advanced. There is also an issue in relation to unlawful means conspiracy, it being clear as a matter of law that it is the combination, the agreement between the various parties which matters in the context of one or more unlawful acts being committed by some of the participants to the combination. The conspiracy itself does not require that each and every conspirator should carry out the individual acts complained of. Here, the conspiracy depends not only on receipt of, let me start that again. The conspiracy does not depend entirely on receipt of the shares by Lane in any event, but on the deprivation of the claimant of its entitlement to shares which went to Ban Canada and Walnut. Its original entitlement to those shares is common ground as a matter of the express shareholders' resolution, which gave rise to the arrangement for a swap. The summary judgment application must fail because, in my judgment, there is a realistic prospect of establishing that there was a receipt of the shares in question, and therefore establishing the claims in knowing receipt, dishonest assistance, and unjust enrichment. Likewise, factual matters require to be resolved in relation to the unlawful means conspiracy. This is, in my judgment, an entirely inappropriate case for either striking out or summary judgment, where there are allegations of dishonesty which will arise as a matter of inference from facts which have yet to be proved. I say nothing as to whether or not those facts will ultimately be proved, of course, but an investigation is needed following full discovery of documents, not just from this defendant, but from the other defendants as well. It is also clear, in my judgment, that there are considerable factual issues which require to be explored in relation to the connections between the Tabares, EFS, Lane, Walnut, and Bannaconda, matters which are all adequately pleaded in the amended particulars of claim. In consequence, there is an arguable case of entitlement to trace, and in addition, it appears to me there are compelling reasons why this matter should go to trial. I will set out these matters in more detail in my reasons, but for all those reasons, each of the applications must fail. Yes, I don't know whether you want to do anything about costs at this stage, or whether that's best left until my reasons are set out in full and the matter can be dealt with thereafter.
Well, Your Honour, that may well be right. Only to make the following points. Firstly, we'll be inviting Your Honour to make an order for immediate assessment, which is obviously the default position given the length of this hearing. And secondly, to point out to Your Honour that we have two statements of costs in relation to these applications. Those are in the bundle at 2427 and 2430. What we've done, what HADF have done, is to apportion 80% of the overall costs of the consolidated applications to the strikeout application, and 20% to the stop notice discharge application. Given that we've been successful on both, the splitting out of them probably is not too problematic. There's also a third statement of costs, and I raise that because it relates to the costs order that Your Honour made on the 11th of February 2025. It's in your order at page 1143, and Your Honour will recall that back in February, or January, we applied for the stop notice application and the strikeout application to be consolidated. That had been opposed by Lane, and Your Honour ordered consolidation. I use that in the general sense, not strictly consolidation, but Your Honour ordered consolidation and made an order for indemnity costs against Lane for resisting the two applications being heard together. So we would invite Your Honour to summarily assess those costs as well, given that they're so closely related to these applications.
Yeah.
It doesn't. Sorry.
Are you inviting me to deal with cost today? Is my immediate question.
Well, given that we have been successful on the applications, and given that the amounts of costs involved do not really depart that much from Lane's costs, I would invite Your Honour to make an immediate assessment today, but I'm obviously in Your Honour's hands on that.
What do you say about that, Mr. Hussain?
Your Honour, I don't think that there can be a order as to cost today. There have been communications between the parties, the substance of which cannot have been before you. And I'm not sure, I need to speak to my learned friend whether they can even be before you now, or whether they have to await the end of the proceedings. I'm not trying to stall. I just don't want to refer to something that I shouldn't be. So I think perhaps if my learned friend and I can have a conversation and await your reasons, and then we can revert to you whether we agree or not. I just want to have a conversation about those documents.
Well, obviously there may be matters of which I'm unaware, but on the face of it, there's an order in relation to the consolidation application that...
Yeah, that's not affected by what you just said, but we have just very recently received that statement of cost. My understanding is my solicitors haven't had time to look at the actual quantum of that, but yet that is not affected by the stuff I mentioned.
All right, well, if there are matters which may or may not be capable of being raised at this stage, then what I suggest is that I produce my reasons, and then the parties, and I will make a provision at the end of the order for agreement either between the parties as to the costs that should be payable, or alternatively, if there have to be submissions, I'll have a short timetable for submissions on costs. The timetable then, unless the parties require a hearing, will involve very brief submissions in writing, and I'll deal with the cost question in writing also without the need for the parties to attend a further hearing. So I'll cover that in the order that's going to be made. All right. Anything else at this stage then?
Your Honour, no.
All right.
Thank you.
Thank you very much to Council and to all those supporting team members behind them. Very grateful to you. And if you wouldn't mind all signing out, I'll have a word with the associate, but you can expect to receive order and reasons within the next few days, subject to the registry carrying out the necessary formatting and so on. Thank you very much indeed.
Your Honour, thank you very much indeed.
Thank you.